over 6 weeks, and people may know who you are, despite my efforts
Hey,
to
everyone.
protect this record. But to the extent I can, I will protect this record and your anonymity as a juror in this record. So just wanted you to understand why I'm addressing you as Juror F.
Welcome to the shit show.
This morning, it was brought to my attention that some jurors were perhaps on their phones listening or looking at a broadcast of the questions to the first juror I examined, Juror Z. Is that something that you know anything about or experienced?
Yes, ma'am.
Did you activate your own phone?
Another juror did.
Oh.
And will what you saw and what you looked at in any way affect your testimony as you're about to give it?
No, ma'am.
Okay. Didn't affect me, but it affected other jurors?
You rendered a verdict on March the 2nd, 2023. The verdict was read in open court and signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript that indicates that the juror complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was your answer an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Absolutely.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Oh, she hesitated.
Was your verdict on
Oh,
March
she
2nd,
hesitated.
2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
Absolutely not.
Very good. That's all the questions I have.
I'd like to discuss the matter with you before we finish with this.
You may go to your jury room and keep yourself ready. I don't know if I'm going to have any further questions, but as far as I'm concerned, the questions that I'm asking are at an end, but I need to consult with the attorneys before I can dismiss you. You may go to your jury room.
This is unbelievable. She just admitted that another juror had their cell phone out in the jury room today, but she was not influenced by it in any way, shape, or form. I call BS. This is insanity.
Yes, sir.
Your Honor, in interviewing the clerk of court for Barnwell County, who worked as an assistant to Ms. Hill during this trial, and interviewing the alternate juror who was not, wasn't needed, wasn't dismissed for any particular reason other than it wasn't needed. Both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle at least once during the trial. So I would ask you ask her during the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss?
What's your position on that, Mr. Waters?
Your Honor, I have no objection to that.
Yes, all right. All right, bring the juror. This is Juror C, returning to the stand. The same juror. Yes. Thank you, ma'am. Of course, you're still under oath. And I have this question for you. During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss? Do you recall that at all?
Could you please ask that again?
Ma'am?
Could you please ask the question again?
Sure.
Sorry.
During the trial, did Becky Hill
Break up the question. Make it simple, Judge.
ride with you in a vehicle before or after court?
There you go.
No, ma'am.
All right.
Okay.
Then I don't need to ask the second
There you go.
question. All right.
Fucking hell. Come on,
This will
man.
conclude your
Keep it simple,
testimony.
stupid.
You are dismissed. I'm going to ask the jurors to stay with me until I've completed this process, and then you are free to go. Thank you so much.
All right. So have the other jurors that have testified, I guess my question is, have the other jurors that have already testified confirmed and agreed with all the other jurors so far? Because I did not watch the first part of it. So maybe you guys in the chat who have been keeping up with this can tell me. I'm curious, has the testimony been kind of unanimous up until this point? Have all the jurors been like, no, Becky Hill has not influenced my decision in any way. This is my verdict, and so on and so forth, such as the testimony of juror C and juror F? Or do we have any conflicting testimony so far? Because that's the only information I'm not privy to at this juncture. Everything else I'm caught up on.
L.
L as in Lima?
L, as in Lima, yes.
Oh, so we have that. The first juror said Becky Hill influenced her decision.
Mm-hmm.
Was that like juror A? The foreperson? Juror Z. Not the foreperson. I'm getting conflicting answers. Juror Z. Z. Okay, so juror Z confirmed that Becky Hill influenced her decision. Mother of God.
Thank you so much. All right. I have redesignated each of the jurors in the record for this case. And so I will be referring to
I
them
found
as
it.
juror
Thank you all.
L as in Lima. And you know, y'all will all.
I mean, that's it. That would be enough in my
for
book.
6 weeks. They may know or be able to.
But they have to keep going. They have to finish the process.
I can protect your anonymity. You don't have to talk to anybody about this at all. It's purely your prerogative.
Julie Grant.
Juror L
Wrote this on Twitter.
You came to testify.
Yep.
And were sworn. You were in the jury room with the other jurors. I understand that some may have looked at their cell phones and looked at pictures of the proceedings as they involved the first juror who was examined. Did you see any of that?
People have their phones out. Yes, ma'am.
Did you look at any of it?
No, ma'am.
All right.
Of course he's going to say
I don't
no.
need to ask you anything further about that. You
I would be
rendered a
terrified.
verdict
Are you
on
kidding?
March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury, and the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was then individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am. Justice, yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, Justice. Yes, ma'am.
Did you hear Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Very good. Juror L, thank you, and you are dismissed. I will send word back by the bailiff if there are any further questions. I always ask the lawyers that before I dismiss the juror completely and go to the next one. Please know that I will keep you in case there's anything I need to have the whole jury for at the end of this proceeding. Then you're free to go, and you don't have to speak to a soul about any of this. Thank you, sir.
When they have a break, I'm going to rewind to Juror Z. So we're going to watch this since I missed that portion of it. Juror Z tells the court that Becky Hill's comment to watch Alex Murdaugh actions and to watch him closely, quote unquote.
Anything further?
Nothing to the defense, Your Honor.
Very good. All right, Mr. Bailiff.
Affected her finding of guilty in the Alec Murdaugh case. That's juror influence. That's a juror being influenced by an outside factor that is not related to the testimony or evidence presented. Therefore, that's a new trial. That's a new trial. That is a new trial. Alec Murdaugh is going to get a new trial. I'm not 99 anymore. I'm 100% confident that Alec Murdaugh is going to get a new trial now. The jury was improperly influenced. I mean, if you all remember when I was down in South Carolina, Danny on direct and I were watching the verdict together. I think I was already back home. Both her and I were completely shocked. We were flabbergasted that the jury voted guilty after there was not enough evidence to support a conviction for murder. And now we understand why that happened, because the jury was improperly influenced. I knew that I was not insane. It's a gut feeling. There was something awry, and now we know what it is. Becky Hill has influenced at least one juror directly.
Sir, I will be addressing you as
And they admitted to
Juror
it.
E this morning.
All right, let's see what Juror E has to say.
Designated the jurors by letter. I realize that you sat on this jury in Carlton County for a lengthy period of time, 6 weeks or better. And people may know who you are, but to the extent I can make this record that protects your anonymity, I am doing that. You don't have to speak to a soul about this matter after you're finished, and your service will be complete, as I'm sure you thought it would be when you rendered your verdict. I have these questions. You rendered a verdict. Oh, yes. It was brought to my attention that cell phones of the jurors were accessed in the jury room for a time, and that some were able to examine the broadcast of the testimony of the first juror called Juror Z. Was your cell phone one of those activated to look at the proceedings?
No, ma'am.
Did you look at the proceedings on any other cell phone?
No, ma'am.
Thank you. Now, you rendered your verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
It was.
Was your verdict based entirely upon the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill in this case?
No.
Thank you, sir. That completes my questions. You may go to the jury room. I always consult with the lawyers to see if there are any further questions. If there are not, please stay with the jury until I dismiss all of you. I'm hoping that won't be too much longer. Thank you, sir.
Okay, so far we have questioned
All right.
about a third of them, it seems like,
Anything from the
maybe
state
close to half.
and from the defendant?
And
Very
so
good.
far we have juror
Bring
Z.
me juror P as in Paul.
Juror Z is the only one that has so far confirmed Becky Hill has influenced them in some capacity. And I have a feeling it's not the end. There's going to be more. There's going to be at least one or two more that are going to say, I have been in some way, shape, or form or capacity influenced by Becky Hill's statement. And yes, I did hear Becky Hill say it. Because realistically speaking, when Becky Hill was talking to the jurors, telling them to watch his movements, I have very strong confidence that she wasn't just talking to one person, but she couldn't have been talking to all 12 of them either. That doesn't make any sense. Like, just logistically speaking, she would literally have to walk into the jury room, and I think that would have been caught way sooner. I think it happened like in the car ride or something like that. So there's going to be at least one or two more for sure.
Good morning. Good morning, man. I will be addressing you as juror P as in Paul. I've tried to redesignate the jurors without their number and of course without their name. Now I realize you spent 6 long weeks hearing this case in open court in Colleton, and many people may know who you are anyway. But to the extent that I can make this record such that it protects your anonymity, I'm going to do that. And you certainly are not obligated to talk with one soul about this.
She's a very cordial judge. I will give her that. I like her, but she needs to control her
Juror
courtroom
B,
better.
I understand that before I began to receive your testimony, that at the beginning when juror Z was being examined, that some jurors may have had cell phones and accessed the proceedings. Did you have your cell phone?
No, ma'am.
Did you examine any cell phone broadcasts?
There was a couple people, but I have no clue.
A couple of people.
Yes, sir. Okay. Did any of this activity by other people in viewing this material have any impact on you in terms of your testimony today?
No, ma'am.
All right. You
Wow.
rendered a verdict.
They're throwing
on
each other under
March
the
the
bus,
2nd,
some of them.
2023.
That's
The
interesting.
verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
It was.
Did you hear Becky Hill, clerk of court for Clarendon County, make any comment about this case before your verdict?
I did. Yes, ma'am.
What did she say?
Here we go.
It was the day that Mr. Murdaugh was taking the stand,
Yes, sir.
and she made a comment about watch his body language.
Oh,
Watch his-
there it
Watch
is.
his body
Called
language.
His body language, I see.
Yes,
Juror
ma'am.
P.
And what else?
That's all I can recall.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
All right. That completes my
Wow.
questions, Juror E,
Oh man.
or P, Juror P. You may go to your jury room. You are free to refuse to discuss this with anybody. That's your prerogative. You're not required to talk about this anymore. That's your business. I've tried to do the best I could to confine this thing, but I appreciate your service. Thank you, sir, and you may go to your jury room.
Thank you, ma'am.
This is horrific. This is absolutely horrific. It goes to show how fragile our legal system really is. Okay, so that's 2 out of 12 already. I mean, 1 was enough.
Any questions by
2
the
is a
state?
crucifixion.
State, Your Honor.
All right, by the defendant.
Nothing, Your Honor.
All right. Bring me.
Look at
your,
Alec. Alec is
oath.
dancing in his seat.
Oh,
Look at how happy he is. He's almost like having trouble hiding that smirk on his face. Look, at the end of the day, I don't blame him. I mean, he's still a fucking shitbag in my book, but does he deserve a new trial? Absolutely. The system must be corrected, otherwise everybody will lose faith in it. I predict at least 1 more, maybe. But I mean, we already got 2. We don't even need a 3rd one, but there's going to be at least 1 more, I think. But I could be wrong.
You swear or affirm that the testimony you're about to give in this case to your truth, the whole truth, nothing but the truth, so help you God?
That's what I'm thinking too, Pastor Flash. Each juror's going to lie about the phone. Like, no one's going to admit, like, oh yeah, I had the cell phone out, Your Honor. I'm in direct violation. Well, actually, there was no order. I don't know.
good
We'll
morning,
see.
juror.
But I would never admit it.
I
You
have
kidding? I'd be terrified.
Designated the jurors by letter in this record so as to try to protect your anonymity as best I can. Now, I realize you sat on this case for 6 weeks in open court in Carlton County, and many may know your identity. But to the extent I can, with the record of this matter, I'm trying to preserve your identity from any disclosure in this court. Juror O, I understand that several jurors may have activated their cell phone during the testimony of the first juror and looked at the proceedings. Are you aware of that?
Yes, ma'am.
Did you activate your cell phone?
No, ma'am, I did not.
Did you watch any of the other cell phones?
No, ma'am, I did not.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said,
It's a good
Madam
question, Kiki.
Forelady and members of the jury,
I'll come back to
if
it.
that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am, I did not.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am, it was not.
Very good. That concludes my questions. You may return to your jury room. I ask that you stay until I've completed the questioning of the jurors. You don't have to talk to a soul about this matter. It's purely your prerogative. And if you have any difficulties in that matter, let me know.
Yes, ma'am.
You are excused.
Very quickly, I think question 2. I don't know that we did question 2.
Resume your seat. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am, it was.
Very good. You're excused.
Sparkle Poots, thank you for being a member
Thank you,
for
Mr.
11 months. And Pin King 554 says, Alec Murdaugh, he has a life sentence basically on the fraud stuff. Absolutely correct. All this does is fix a
Right.
wrong with a new
Bring the
trial.
juror
100%
live.
agree. 100% agree. Pin King
Oh,
554.
excuse me. Sorry. All right. Nothing further, Ms. Morris. Thank you.
He deserves a new trial. That's corruption at its finest. Absolutely. So to answer your question, Kiki, do you think the judge will overturn the verdict if the jurors are saying Becky's words didn't affect their verdict? Yes, and here's why. Because when you have communications between a person of power in the
Do you swear
in
to
the
affirm
court
the testimony you're about to give in this case?
communicating with jurors who are going to be deciding a verdict in a case while the case is still pending, there is the implication that they're going to be influenced. They will never admit to it, but there's the implication that they have been influenced.
Good morning, sir. I will be addressing you as Juror Y. I've tried to re-identify the jurors so as to preserve your anonymity in this record. Now, I know that you sat on this case for 6 weeks in open court, and many have seen you. They may know who you are. But as to the extent I can preserve your anonymity in the record of this case, I have tried to do so. You are completely free not to talk to a soul about this matter. That's always your prerogative. I understand that before you came out here, when the first juror to be examined was being examined, that some jurors may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am.
Were you aware that some cell phones might have been activated?
I was aware after that.
All right, sir.
I was aware after the
Did you
fact.
hear
Oh, come on.
anything about the examination of the first juror?
No, ma'am.
Thank you, sir. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Not to me.
Did you hear her make a comment to anybody else?
Pause.
Not that I'm aware, ma'am.
What?
All right.
That's a
So you
lie.
don't remember any details of any
You
conversation?
paused way too
No,
long.
All right, sir. Was your verdict on March the 2nd, 2023, influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Thank you, sir.
He's
That
terrified.
completes
I
my
mean, I can't
question.
blame him.
I'm going to excuse
But that was a
you.
lie.
Stay together with the other jurors.
He wanted to tell the
while I
truth, but he got
conclude my
scared at the last
examination,
second.
And then you will be free to go. Thank you so much.
He got scared. He got fucking scared. This is insanity. They're achieving half a job because of the jurors' fear of what's going to happen to them. Look, and I get it. I completely understand. If I were in their shoes, I would probably be shitting my pants on that witness stand because
Bring
now
me juror
I don't know what
W.
what the consequences are. Am I going to go to jail because I have been influenced? Like, am I deceiving the court? Am I like, as a juror, I would be like horrified, mortified, terrified, scared shitless of having to sit there and talk to a judge about a case that I decided almost a year ago. I understand that. There's got to be a better way to do this, but there's not. I mean, what else do you do? Hold a closed hearing? Well, then where's the justice there? I like that this is public and we're able to watch it and comment on it. As a matter of fact, this is the best that we can possibly ask for, in my opinion. That's right. The rabbit hole goes a lot deeper, Alabama Rose.
Good morning. I'll address you as Juror W. I have redesignated by letter the identities of the jurors
Exactly,
as I
Kiki.
question them today.
Yes, ma'am.
And you know, you sat on this jury for 6 long weeks, and I'm sure that those who were there in the trial for a long period of time may know who you are. I'm just doing the very best I can to make your participation in this matter anonymous, and I will preserve that anonymity. You are free to not talk to one single soul about this if you don't want to. That's purely your prerogative.
Yes, ma'am.
I understand that when the first juror was being questioned, some members of the jury, as you were back in the jury room, may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am. I left my phone in the car.
And did
I left
you
my
hear
phone in the
any,
car. That's an interesting follow-up.
information coming from anybody else's cell phones about that examination?
I did.
All right. Does that have any impact on the testimony you are going to give today?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
All right.
I can
Was
hear
your
her
verdict
voice
based
shaking.
entirely on the testimony, evidence, and law presented to you in this matter?
Yes, ma'am.
Did you hear Ms. Becky Hill, the clerk of court for Clarendon County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am.
Very good. That is the end of my questions, Madam Juror. You may go to the jury room, stay with the jury until I've completed the questioning, and then you're free to go, and you're free not to say anything you don't want to say. And if anybody upsets you or bothers you in any way about that, you just let the court know.
Yes, ma'am.
Thank you.
Oh man. I could hear her voice shaking. I could hear like how terrified she was.
Any further questions from the state? Any further questions?
Nothing
from
further,
the
French.
I'm not surprised, Carla.
All right. Bring me juror Q.
Carla says Jersey's voice was shaking as well. Imagine being the first juror to testify. Yeah, no kidding. Will Becky Hill face charges? I think they're investigating her still, but she's also got, other than the jury tampering, she's also got like a misappropriation of funds potential charge. So she's been using funds for improper things in the office, and there's like a multitude of allegations. If you, we can talk about it at the end of this hearing. I'm happy to. Just remind me if I forget. And then the other question that was by Richard Hawk, by the way, shout out to you, Richard. I know you've been calling every single jerk coming up there a liar. I love that, because I'm with you like 100%. Will they bring Becky before the judge? I sure as hell hope so, but I don't think it's going to happen at this hearing. But it might. I sure hope so. I hope they will. Don't forget to like this video, comment below, subscribe to the channel. I love you all.
Good morning. I will be referring to you as Juror Q. I have redesignated every one of the jurors by a letter. And in that way, I'm trying to protect your anonymity in these proceedings. Now, I realize that you spent 6 long weeks hearing this case in open court in Colleton County, and some folk may know who you are, but I'm trying to protect your anonymity in these proceedings as best I can. You don't have to speak to a soul about these proceedings after you have completed your testimony. That's purely up to you. And if anybody hassles you about anything, the court stands ready to assist. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the
Two,
person of the
BB.
jury.
Two.
The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer
Yes, ma'am, it was.
about your verdict at the time?
Yes.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way with any communication by the clerk of court, Becky Hill, in this case?
No, ma'am, it was not.
Very good.
I'm not gonna lie, you all. I'm getting like
You may be
secondhand
excused
social
and,
anxiety from
you
this
to
case
stay
right
in
now.
the jury
Like I
room
feel these
till the
jurors.
completed examination of all the jurors. Thank you, sir.
Thank you.
Your Honor, very briefly,
Do you all feel the same
I
way?
know we were doing the cell phone inquiry.
Yes.
With various jurors. I
Yes.
don't know if you wanted to have that with this particular juror as well.
Sure.
Like I'm
I
legit
understand
feeling
that,
like
before
secondhand social
I
anxiety
began,
from this.
Questioning you or the other jurors on the questioning of the first
I would be
juror,
mortified.
some jurors in the assembly room may have activated their cell phones. Were you one of the jurors that activated your cell phone?
Yes, ma'am.
Oh,
And was anything that you heard at that time something that has any influence or effect on the testimony you now give under oath?
No, ma'am.
All right.
of course not. Of course it's
Thank
gonna
you.
say no, but
Anything further?
we got it. Was that juror Q?
You may go to the jury room.
I missed it. Was that juror Q that admitted that he had the cell phone out?
For the state.
Nothing, Your Honor. Nothing, Your Honor.
All right.
Juror Q.
Bring me juror K.
Wow.
Do you swear or affirm that the testimony you're about to give in this case will be true, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Oh my gosh.
Good morning. I will be addressing you as juror K. I redesignated each of you jurors and gave you a letter for purposes of this hearing. I'm trying to protect your anonymity as best I can. Now, I realize you sat for 6 long weeks on this case in Colleton County, and many folk may know who you are. But on the record of this matter, as best I can, I'm trying to preserve your anonymity. Please know that you don't have to answer anybody's questions about this matter in any way, shape, or form, purely up to you. And if anything is done that you feel is harassing or makes you uncomfortable, you contact the court.
We'll talk about it. Will it grow?
Try to do as best I can to help in that situation.
I'll bookmark your question.
All right. I understand that during the testimony of the first juror, some opened their cell phones in the jury room, in our jury assembly room here. Were you one who opened her cell phone?
Yes, ma'am.
Another
Did
one.
you listen to the or watch the broadcast of that first juror's examination?
We were on Facebook.
Ma'am,
I was on Facebook
it was on Facebook, and you watched it.
when we closed it.
All right. Did anything that you
Oh.
heard in that Facebook cell phone access impact or influence your testimony in this matter in any way?
No.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, ma'am. That completes my questions. I'll let you go to the jury room now. I'll then ask the attorneys whether there are any further questions. If there are not, please just stay in the jury assembly room until I give you the word that you are all to come out one more time, and I dismiss you.
So far we have jurors Q and K admit that they were listening in some way, shape, or form or capacity, or at least had their cell phones or access to their cell phones. Look at that smirk on his face, by the way. He's just elated. Look, again, I don't blame him. You're still a shitbag, bro. Now, you're on cloud 9 right now. I feel you.
Nothing to the bench, Your Honor.
So we have juror K and juror Q.
This then completes the questioning of the jurors. I will ask the jurors to come into the open courtroom again, thank them, and dismiss them. Anything further before I do that?
None from the state, Your Honor.
So jurors K and Q, we have confirmation that they had access to their cell phones and they used their cell phones in the back room today. And we have jurors Z and P, Z as in zebra, P as in
Your Honor,
Paul.
I would move for the record that I be able to question juror Z to follow up on what I believe the court is confused about.
Very good. I deny the request. Anything further?
That's bullshit.
All right, bring me the jury.
Jurors Z and P both admitted that Becky Hill spoke to them and communicated that they should be watching Alec Murdaugh's body language when he testifies. But according to them, it did not influence their decision. Again, I do not believe it one bit. And this should guarantee a new trial. If it doesn't, I'm going to lose all faith in our judicial system. Like, not even joking. As a trial lawyer, this terrifies me. This absolutely mortifies me. How did we get here? Like, I don't understand how we got here. I guess Becky Hill thought it's a small town, no one's going to pay attention. Lady, the whole world was watching that trial.
Sure, you see you, Your Honor.
How gullible are you? And then you write a book, profiteering
Ladies
from
and
it.
gentlemen of the jury, that completes the court's examination of the jurors in this matter. I can only deeply apologize to you for having to inconvenience you so long after the trial of this case to come here, and I very much appreciate your candor. There are no right or wrong answers to the questions I asked you, but I think each of you, to the best of your ability, answered the questions, and I am deeply grateful for that, as is the state of South Carolina, as is the defendant. You don't have to speak to a soul about this matter if you don't want to. That's purely your prerogative. If there's any
The attorney wanted to
difficulty
clarify some
about
question that the
hearing
court had,
that
and she
I
just
can
denied
help
it.
with, please contact the court.
Sparkle
And I'll
Poots.
be happy to do so. You are dismissed this time. You may go. Thank you for your service. Excuse the jurors.
Will It Grow asks, DUI guy, this shows that the jury broke rules, so who knows what they're not saying. Again, there was no admonition. The judge screwed up, as the title suggests of this video. I titled it because I already knew it happened before I before I went live, since I didn't watch from the very beginning, which we will rewind in a minute. For those of you who missed it, I missed it too, so I want to go back. They didn't really break any rules because the judge failed in her job. She failed to admonish the jury. Her responsibility was to admonish the jury.
Court available?
Yes, ma'am.
Oh, they're gonna call Becky?
Understanding she is, and the state's prepared to call her when the court is ready.
Oh! Oh my God!
She's at a location. Mr. Lewis is here.
This is
Just a
incredible.
block or two away. So if we take a brief recess, we'd be prepared to present.
They're gonna call Becky Hill.
Well, I will entertain going on and taking an early lunch break. I don't know how long Ms. Hill's testimony is going to take.
She wants to give her enough time to
If that might be
prepare.
a better thing than hanging around.
Or are you just
here, I think
hungry?
that's what I would prefer to do, Mr. Harpootlian.
Your Honor, I need sustenance.
I need. Okay, all right. Everybody's
So
hungry.
I
Blah
think I
blah
will
blah.
join you in that. What I will
I
do
didn't.
is I will recess court until
She's gonna faint. Oh my God.
1:15.
1:15. Okay, so we got an hour and a half.
1:15.
Thank you, Your Honor.
Oh my God. This is going to be great. I wonder if she's going to plead the fifth. I would. Because look at it. I mean, think about it. She is under investigation currently, as we sit here today. She's under investigation for at least 2 violations, right? The first is jury tampering. First, she's allegedly tampered with jurors by influencing them improperly by communicating with them during the trial and mentioning to at least 2 of them, jurors Z and juror P as in Paul, that pay attention. She said, pay attention to Alec Murdaugh's body language when he testifies. Basically insinuating that he's a lying sack of shit, which we already knew. But that's not the point. If the jurors come to that conclusion themselves, that's fine. That's fine. But if you have, and again, think of the person, think of the position that the individual that has influenced them, Becky Hill, is in. She is the clerk of court. She holds immense power in their eyes. To them, she's like a very important figure.
High-speed chases.
I mean, it's normal. You know, it's normal. It's understandable why they would listen to her over like somebody else, let's say, you know, who's not like involved in the court system. Let's say like one of the, I'm just going to remove it for now because they're playing commercials. Becky Hill holds immense power, and not just in their eyes. I mean, realistically speaking. So all these jurors saying it did not influence their decision, I think they're just scared of consequences. I think the court should have let them know at the outset. Like if I were the judge, and maybe I'm wrong, maybe they can face consequences, but I don't think so because they're not at fault here. They're not at fault here. Like, what would you? First of all, I would never want to see a juror charged with anything that's not their fault, and this is clearly not their fault. They did not come to Becky and say, "Hey, could you give us any more info?" She injected herself into the jury, and therefore Becky is the culprit, and the jury is innocent in this whole ordeal. So I do not want to see any charges for the jury. I want to see charges against Becky. And I think I cannot wait to see what Becky has to say. This is rough. This is very rough. So let's take a look. Let's examine Becky Hill's future. What is she looking at? For those of you who are just catching up, oh, wait a second. Before we do that, I'm sorry. Before we do that, I want to go, excuse me, sorry. I'm still a little bit under the weather. I'm going to try not to cough directly into the microphone. But for those of you who missed it, because I missed it too, I want to go back. I want to go back to juror Z. Okay? So for those of you who missed it, because I missed it as well, let's go back to juror Z. If anybody can provide me with a timestamp, I will love you forever. But I'm going to try and find it myself. Why is there no sound? Is there no sound? Oh, I guess there's just no
I don't
sound.
want any photographs by this silence. Allow any photographs each court to conduct press. The jury are in place in the jury room, Mr. Bailiff.
Yes, Your Honor.
Very good. Bring me the jurors.
Okay, so she's bringing in all the jurors. This is the beginning.
Sure.
Okay, we're going back in
Hold on a
time.
minute.
This
Your
happened
Honor,
2 hours
you have a
ago.
list of questions you distributed to us, and
Yes, sir.
of course you went through those with juror.
Z.
And by the way, some of you have already asked a polygraph. Somebody said they should give them a polygraph. Unfortunately, those are not admissible in court. But that's a good attempt, Matt Sands. Frosted Sleet says, if a retrial, who pays for Murdaugh lawyers? Murdaugh is going to pay for him. His family, he himself. You pay for your own lawyers. You have to pay them again. This shows that the jury broke the rules. So, okay, that's what I already answered. They didn't really break any rules because she forgot to admonish them. Okay.
Or
X. I knew it was one of those
Yeah.
last letters. Juror X. The third question you say, did you hear Ms. Becky Hill make any comments about the merits of this case before your verdict?
Yes, sir.
And clearly the juror didn't understand what the word merits meant.
I disagree with that, but you may make your record about that. I think the juror understood what was being asked. And frankly, in some of the materials that we exchanged back and forth about questions, you yourself have used the word merit. So I don't think she was confused.
Well, Your Honor, occasionally I make a mistake. I think in this case, perhaps you made a mistake. And if you would just respectfully use the words, did make any comment about the case before your verdict, just leaves out their judgment about merits. They don't know if merits is a legal word.
She's still under oath.
When, if anything, did Becky or
Waters?
Your Honor, I have no objection to that, Your Honor.
All right, who are we bringing? Is this juror Z? I'm trying to find the timestamp. Alabama Rose.
Yes, all right.
Thanks for the timestamp.
All right, bring the juror.
Which one is
This
this?
is juror C, returning to the stand.
C. No, this is C. Returning to the stand. That's not Z.
The same juror. Yes.
My timestamp may be off. Ah, shucks.
The conversation, lawyers for juror,
both being true?
statement of what she said.
Yes, ma'am.
And she and the foreperson would go, what your recollection is.
Z was before C. Okay, so. But that was
David, and then I'm going to question her about it.
C being recalled.
Based entirely. Yes, sir. C.
Oh, here we go. I think that's Z.
Bring me juror Z.
Yes, found it. Okay, perfect. Here we go. So this happened about an hour ago, hour and a half. This is the other juror that dropped the truth bomb that cascaded this whole thing this morning. Becky is going to be on in an hour and 20 minutes. DSCBX. Don't miss it. She's going to be testifying. It is going to be. I can't wait. I cannot wait. And then we'll talk about the investigation into Becky Hill.
Juror Z, you may take the witness box after you are sworn. Step over here to the clerk and she will administer the oath.
Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you for this.
Juror Z, I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Pause. Long pause.
Yes, ma'am.
Right? Was your verdict based entirely on the testimony, evidence,
I don't believe her.
presented to you in this case?
Yes, ma'am.
She's lying.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There is, but I can't remember.
Okay, that's fine. Was your verdict on March the 2nd, 2023, in any way, with any, influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am.
Yes, ma'am.
Yes. please.
My
All right.
communications with
Was
Becky
your
Hill
verdict
influenced. That's it.
influenced
That's enough.
in any way by the communications of the clerk of court in this case?
Yes, ma'am.
She just said yes. Why are you
And
asking
how
it
was it
again?
influenced?
To me, it felt like she made it seem like he was already guilty.
Oh,
And I understand that.
He was already
that's
guilty.
the tenor of the remarks she made. Did that affect your finding? of
She just
guilty
said
in this
yes.
case?
Stop grilling her.
Yes, ma'am.
Beautiful.
Right?
That's it.
Be at ease.
I mean, the judge is shook. The judge is shook.
Those are my questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room.
For the record, by the way, folks, for the record, that right there is enough. You have Jersey, who is clearly just testified in open court over and over again. Like 3 times she gave the same answer. I think the judge was waiting for her to change her answer. That, which is despicable behavior, by the way. The one is enough. She knows the juror is in the hot seat, and she is using her position of power to try and kind of maybe like put pressure. Maybe she'll change her answer, which I do not like at all. But I understand like why she's doing it, because she does not want any type of like new trial or anything. Because why open up a case that's already closed? I mean, I understand it, but that's improper. The judge should have asked it once and moved on to the next question. She asked it 3 times. Were you influenced in any way, shape, or form by the communications from Becky Hill? Yes, I was. Did it influence your verdict? Yes, it did. Case closed. That's it. You forget about the other 11. It doesn't even matter anymore. You have 1 tainted out of 12. It must be a unanimous verdict. So it is a calculus. If you want to look at it as a calculus, it's an if-then statement. If at least 1 juror was influenced in their decision by an outside force that is not related to the evidence presented in the case, then because the jury must have a unanimous decision, it's not an 11-1, it's not a 10-2, it must be a 12-0. And in this case, we already have 11 and 1 tainted. Therefore, it's not a unanimous 12, and therefore a new trial must be granted. That's it. That is it. It's a simple if-then statement. That right there crucified the case. A new trial will be granted 100%. It has to be. There is no other way out anymore. Now, I'm still fascinated to see what Becky Hill is going to say and how she's going to try and dance her way out of this. I hope she retained counsel, number 1. Number 2, I hope counsel told her to plead the 5th, which if she does, that's it. This case is done. And Alec Murdaugh is going to get a new trial. And we're going back to South Carolina for the retrial, which is not going to be as interesting, but I'm anticipating a lot of contradictions. And maybe they'll make him an offer he can't refuse, because the state is also going to be scared of their contradictions. If their officers and their people that are going to testify in the trial are going to be making a lot of contradictions and they're afraid of it because they've been lying through their teeth the entire trial, it's going to be interesting to see how this whole thing unfolds. Because now, again, I'm speaking as a lawyer, as a trial lawyer, based on what I have seen so far, especially with that juror Z, is a crucifixion on the verdict. The verdict cannot stand, period. Cannot stand. So even if only 1 was tainted, that's enough. By the way, some of you in the chat were talking about the affidavit that was submitted to the court. Which juror submitted the affidavit? Do we know? Is it juror Z? Or is it somebody else? Or is it some other juror? It was this one, Z. Okay. That's what I suspected. That makes sense. Julie, thank you so much. You're saying, but the juror walked that back saying the other jury influenced her, not Becky. Let's see. Let's keep watching.
Just tell me whether I need to do that. All right, sir.
Okay, I have to address this real quick because I've been getting this question a lot. I am aware that there is a case out in Paducah of an individual whose rights were violated. She, or maybe this is a different one. Actually, I thought it was a female. There's like a couple of potential civil rights violations out of Paducah going on right now. And I practice in Kentucky, so I could represent them. And people have been reaching out to me, and I thank you all very, very much, honestly, sincerely. Like, you should help this person. They need your help, and blah, blah, blah. And I would love to help them, but I cannot reach out to them myself. I cannot pick up the phone and go, hey, I heard you got in trouble. Need a lawyer? Because I am going to be in direct violation of solicitation ethics rules. I cannot solicit clients. Like, imagine if there's a wreck and I'm like, hey, here's my card if you need a lawyer for your injuries. I can't do that. I mean, it's disgusting, first of all. Second of all, it is a violation of ethics rules. I could lose my license if I do that. Now, if they reach out to me because they're like, Larry is the man, you need to talk to Larry, blah, 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 whatever, and they call me, then I can help them. But I cannot personally pick up the phone and go, hey, I heard your rights were violated. Need a lawyer? You know, got lawyer, like the hashtag got milk. Remember those? I can't do that. I'm not allowed to do that. So if they call me, that's fine. You want to put a bug in their ear and be like, you should call Larry? That's fine. There's no violation there. But I personally cannot reach out. So I really appreciate all of your efforts, but unfortunately, I my hands are tied. My hands are completely tied. And commercials are 100% legit. You can do as many commercials as you want. Anyway, let's get back into it.
We need to put some things on the record.
All right. Take the juror to the jury room, please. Yeah, that's fine. All right, Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given by this particular juror, paragraph 10 said that I had questions about Mr. Murdaugh's guilt, but I felt guilty because I felt pressured by the other jurors. We would request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously the answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
All right.
Thank you, Your Honor.
Mr. Buckler?
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit to refresh her memory of, she said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court a copy of her affidavit and ask you to have her read it for
I really appreciate it, TD. See, that I can do. If you share my information with the potential client, and they decide not to reach out, that's it. You've done your job. Thank you. Honestly, just thank you for the effort. That's all I can say. Because I did not ask you to do that. You voluntarily, you know me, you reached out to the potential client, and the potential client decided not to move forward with my services. That's totally fine. But I cannot reach out to them directly. All right, you guys got it.
I have here from Mr. Waters for the record. Mr. Waters, what I've been handed for the record is something, affidavit of juror, now referred to as Z. It was taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian, and he would like for me to give that to the juror and ask her to read it and then ask her about it. I'm inclined to do that, but I'm going to hear from you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state. So we have no objection to that.
Very good. It will be done.
Your Honor, also, we would ask that you not ask the question that that Mr. Waters asked you to ask, because it violates Rule 606B, which provides upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
It's paragraph 10, Your Honor.
paragraph 10,
It's in the very affidavit.
she said she was influenced by other jurors.
Yeah,
Okay.
I'm going to ask her about that. I'm going to give her the affidavit and then I'm going to question her about it.
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
You're the
issue.
one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. And that's
Well, you want me to admit it and have her examined
No, I
on it.
want you to have her read it to refresh her memory.
We're quibbling, Mr. Harper, we're quibbling about things that I'm not going to take time to quibble about. My ruling is pursuant to your request, I am going to allow the juror to examine her affidavit.
Maybe.
and
I
then
solemnly
I'm going to
swear,
question
maybe.
her about it. That's my ruling. Your objection is overruled.
For the record, I just want to note, Your Honor,
Just one, Kyle.
You noted
Just one,
606.
as far as I know.
hear you noted.
in no way waiving anything or opening any door by asking you to let her
That's
examine.
for a higher court than me to decide.
Well, I understand that, and that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence. I'm asking you to
Well,
let
I
the
don't
jury
see
examine.
how in the world I can question the juror about something and not put it into evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given, but you have chosen to ask about this.
Wrong request.
Denied.
Your Honor, all the time we ask witnesses to examine a prior statement.
Mr. Harpootlian, I
Good
beg my-
Lord.
Please take your seat. All right, bring juror Z.
Wow.
Get me another copy.
It's in here.
What an unreasonable judge. I'm sorry.
Yeah.
But it's true. This is the Alec Murdaugh hearing on the Becky Hill interference with jurors, so you say. In the Alex Murdaugh case. It looked like they were holding hands for a second. I was like, what was that about? Sorry, you guys. I'm still a little sick. I've been like coughing up a lung all weekend, but I'm getting better. I have so many drugs in my system right now just so I can function. I'm just going to skip because there's nothing happening. Here we go.
The first paragraph, of course, is a statement that you are a juror in the case. Second paragraph says, toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
Yes, ma'am.
Is there anything in the statement that on reflection you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote, watch him closely, quote, immediately before he testified, including, quote, look at his actions, quote, and, quote, look at his movements, quote, which I understood to mean he was guilty. Is that an accurate recitation of your view of the matter?
Yes, ma'am.
Number 4, paragraph 4. Immediately after he testified, the foreperson said Mr. Murdaugh was crying on cue. Is that an accurate statement of what you saw and heard?
Yes, ma'am.
5, the foreperson criticized the former foreperson for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury, we cannot interact with Mr. Murdaugh. That's what the defense wants us to do. Do you still stand by that recitation of that conversation?
Yes, ma'am.
Right. Number 6, the jury frequently discussed the case during breaks before deliberation. Is that correct?
Yes, ma'am.
Oh.
Number 7, toward the end
Wait.
of
Wait. Pause. That right there also by itself as a standalone is enough for a new trial, because that right there, forget everything else for just a second. Okay. I know we have so much going on, but let's focus on this one. I want to play it again for those of you who missed it. I want to play it again. Listen very, very closely to what the judge is asking, what the juror says.
We cannot interact with Mr. Murdaugh because that's what the mission of that conversation.
Yes, ma'am.
Right. Number 6, the jury frequently discussed
Here,
the case.
right here, number 6. Okay, listen very closely, chat. This is very important.
Yeah.
Right. Number 6, the jury frequently discussed the case during breaks before deliberation.
The jury frequently discussed the case before deliberation.
Is that correct?
Yes, ma'am.
Yes, ma'am. Okay, so let's unpack that, because that right there by itself as a standalone, again, I as a trial lawyer in an appeal after losing a case would be doing the following. The juror just admitted openly in open court upon essentially direct examination by the judge that I, juror Z, along with other jurors unnamed, have frequently, to quote the judge, to quote the affidavit, to quote the juror, have frequently discussed the case during the case before deliberations. They were under strict orders by Judge, who was it? Judge Newman, I think. I forget the judge's name, who was originally on the case in February, March last year. Chat, please fill me in. The judge has strict instructions. You are not to discuss the case until all the evidence has been presented to you. Okay? Again, all of these are like mini logic games. They're really fun to dissect and understand. So I'm trying to make this as fun as I can for you. The judge has a standing order. You shall not discuss the case until all the evidence has been presented to you and you're ready to deliberate. That juror just admitted in their affidavit, as the judge asked, and right now on the stand, that yes, they have deliberated on the facts of the case before deliberations. I will play it one more time because this is crucial. Paragraph 6.
Act with Mr. Stand by that the jury frequently discussion.
Yes, ma'am.
Number 6, the jury frequently discussed the case during breaks before deliberation.
The jury frequently discussed the case during breaks before deliberation. That's enough for a new trial. You don't need anything else. Now we have a lot more, but we don't need anything else.
Is that correct?
Yes, ma'am.
All right. Number 7, toward the end of the trial, Ms. Hill came into the jury room a lot. Is that your recollection?
Yes,
She
ma'am.
came into the jury room?
Ms. Hill and the foreperson had private conversations on multiple occasions. The foreperson would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson would go to another room for a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently towards the end of the trial. Is that still your recollection of the interaction?
Yes, ma'am.
9, when we began deliberations, Ms. Hill told us this shouldn't take us long, quote. And if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations were complete. Did you hear that?
Yes, ma'am.
Including the business about the smokers?
Yes, ma'am.
All right. Number 10, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that an accurate statement about your verdict?
Yes, ma'am.
After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. Is that an accurate statement of what she said?
Yes, ma'am.
And did some jurors decline to do that?
Yes, ma'am.
She doesn't have to, Marty. She doesn't have to say Your Honor. I mean, it's just cordial politeness. I know, right, Samantha? Back to low country you go, Larry. And thank you, Alabama Rose, for being a member for 19 months. Oh my God, over a year and a half. Jeez Louise. Welcome back.
Juror Z, I asked you previously, was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Overruled.
Yes, ma'am.
All right. So you do stand by the affidavit?
Yes, ma'am.
Very good. Thank you. All right. You may go to the jury room. And let me just explain to you what the procedure will be. I'm calling the rest of the jurors, of course, one by one. When I am finished with that, I will bring you out as a group one more time, and then you're free to leave. You don't have to stay. Okay? Very good. You may go to the jury room. What's that?
Before this juror is excused, but after she steps out, I'd like to address
All
the
right.
court.
You may be excused.
Yeah, but jurors lie, Michelle Eby. You make a good point, but they may have easily lied. Michelle is saying 2 jurors made that claim after the fact, after being polled after the verdict, about the verdict as a group and individually, and they all indicated that the guilty verdict was in fact their verdict.
Just very quick.
And they may have lied.
Redacted copy I can hand over to the court if you want to make that use of the court's exhibit, please.
That's good. What I'm going to try to do is redact as I did in the as you did in the document that you sent me. The identifying thing redacted now.
He has an extra copy of it redacted.
I have
Oh,
it right here.
oh, good. That's great. That would be wonderful. Show it to Mr. Harpoon.
I see.
Very good. Thank you. That's the one I will give to the court reporter, but I think you can see that I asked off of it. This is a court's exhibit. Court's exhibit 3.
Your Honor, just to be clear, that does still have the juror numbers in it. It does not have the letters.
All right. What I'd ask you to do, Elizabeth, is take off the juror numbers, just strike them through, and then where it says affidavit of juror and gives a number, just strike that out and you can put in pen Z. Thank you. Yes, sir. Mr. Harper.
Your Honor, we objected to the questioning because this juror gave 2 statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
Yes.
The one she gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say. And we believe that this juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true.
I declined.
And she's going to decline it, and then she'll decline it again later. That's the question. Somebody asked, what was the question that Poot wanted to ask the juror that the judge denied at the end of the morning hearing? That's what it was right there. Just to clarify the answer, that it's okay to have yes to both questions. It's not a contradiction in terms.
Mr. Bailiff? Yes, sir.
Thank you, Star Saucer, for being a member for 20 months. Even, wow, almost 2 years. Thank you for hosting this and your input. Absolutely. This is, I just couldn't let this one go by. When I saw them streaming it, I was like, I need to The lady on the prosecution side, Larry, I see a love match. You trying to hook me up, brother? No, I'm already hitched. Sorry. Although I was wondering about that sex symbol sitting at the prosecution table. I guess they were hoping for a male judge and they got a female judge. I don't know. I don't know what that's all about. She's not dressed like a lawyer. I'm sorry. And we're talking about this lady right here, by the way. The one on the left right here. She's got cleavage showing. She's got the short skirt. I mean, I'm sorry. That's not court appropriate.
Your Honor, we have a 5-minute recess to discuss what we need to put on the record. I mean, this is.
I'm not gonna take all day.
Okay, so we picked up from right here. We picked up from right here. So we're caught up. Now we're caught up on the important part. Court is in recess. So court is going to be in recess for the next 45 minutes. So here's what we're going to do. I want to show you all the criminal investigation into Becky Hill. There are a couple of articles that I have found on this issue, and I'm going to pull it up. I'm going to pull it up real quick. Give me just a moment. It's this one.
Now to breaking news in the Becky Hill
And I'll be right
case.
back.
She's the Colleton County Clerk of Court accused of wrongdoing and possible jury tampering during the double murder trial involving convicted former Low Country lawyer Alec Murdaugh. We just got brand new information from state police. Joining us now is our investigative reporter, Ann Emerson. Ann, what are they saying tonight?
Well, Katie, state police just confirmed there are now 2 open investigations into Colleton County Clerk of Court Becky Hill. Right now, Hill is at the center of a firestorm of allegations. One of these investigations centers around whether Hill used her elected position for personal gain. These are some of the same allegations we first learned about in an ethics complaint. The second investigation is regarding her alleged interactions with the jury in Alec Murdaugh's double murder trial. We were aware that SLED was investigating the accusations into the jury tampering, which Hill is accused of having a role in. Now, the jury tampering issue is scheduled to be heard at Murdaugh's retrial hearing in Columbia at the end of this month. Working for you, Ann Emerson, back to you.
Chris, thank you. It all comes down to today. Alec Murdaugh's chance of overturning his double murder convictions depend on what happens today inside a courtroom.
And former Chief Justice Jean Toll will hear testimony about jury tampering. She'll decide if Murdaugh should get a new trial. That's taking place in Columbia, and that's where we find our investigative reporter, Ann Emerson.
Good morning. In just a few hours, 11 jurors from Alec Murdaugh's double murder trial and the Colleton County Clerk of Court, Becky Hill, will be here to answer questions about jury tampering allegations. On Friday, we heard from one juror ahead of today's proceedings. That testimony and the questions asked were kept under wraps all weekend by order of the judge. Today, however, cameras and audio are allowed in the courtroom. The jurors will be asked the same series of questions, but their identity will still be protected. Alec Murdaugh is expected to be present with his defense team, as he was for Friday's juror questioning.
You know, this has been on these jurors' minds for basically 5-6 months, because that's when the defense made their motion, I think in late August, about this issue. So, you know, they don't want to go back and relive the Murdaugh trial all over again. I'm sure they just want to get on with their lives. So
yeah,
that's, I think, what Justice Toll is trying to do. And we heard that it's possible that the hearing will only be one day.
Of course, Becky Hill will also take the stand. Hill is the state's witness and went under an hours-long pre-briefing before today's hearing. The defense will be allowed to cross-examine her as well. Justice
So I
Toll
imagine
said
she's not going
this
to take the
hearing
fifth.
could wrap up by the end of today, but we don't know when she's actually going to rule on this request for a retrial hearing. Reporting in Columbia, I'm Ann Emerson.
Well, I hope you enjoyed your Sunday. Today wasn't as...
Okay. So that's the article from 3 weeks ago. Let's see if I can make it bigger so you guys can see it if you're like on a TV or a small screen or something like that. Walterboro, South Carolina. State police in South Carolina say they are investigating the possibility Becky Hill, Colleton County's elected clerk of court, may have abused her government position for financial gain. So basically, using your position for benefit, for your own personal benefit. A public office cannot be used for personal gain. That's obvious. SLED confirms that is one of 2 criminal probes the agency directives have open involving Becky Hill. SLED spokesperson Renee Wunderlich said on Tuesday, which was, like I said, 3 weeks ago, so it's not this past Tuesday. SLED's inquiry focusing on Hill's possible use of her elected office for improper personal benefit has not been previously acknowledged by state police. SLED's other open investigation into Hill concerns her reported interactions with the jury in the infamous Alec Murdaugh murder trial. That investigation has been previously confirmed and reported. That's just some photos not related. Hill garnered modest public fame through her front and center role as a court administrator during the Murdaugh murder trial, which included reading the jury's guilty verdict as audiences watched live on television and internet streams internationally. Internationally. I mean, this case got notoriety all across the world because there was a lawyer accused of not just fraud, which he admitted to, but murder. A disbarred lawyer, no less. That's why it got such huge notoriety. Hill went on to do several media interviews, appeared in documentaries about the Murdaugh saga, and hastily wrote a self-published memoir about her involvement in the trial. But her quasi-fame has been followed by a firestorm of scrutiny through the latter half of 2023, leading into 2024. See, even Bob says he watched it all the way from the UK. There we go. It began quietly in June when a concerned person filed an ethics complaint against Hill with the South Carolina State Ethics Commission. The complaint accuses Hill of self-serving behavior during and after the Murdaugh trial, saying she, quote, utilized her authority, the Colleton County Courthouse, and taxpayers' money outside the scope of routine court business, end quote, to benefit herself financially. Here are some of the specific allegations named in that ethics complaint against Becky Hill by this individual. We don't know if it's a juror, a lawyer, or somebody else because they're not named directly in this article. Number 1, Becky Hill used her political office to obtain and release confidential information and materials. So she used her political office to obtain and release confidential info and materials. I imagine to the public, to the jurors, we don't know. Number 2, Becky Hill used her office to promote her book and the book written by another journalist. I think that much is obvious. This one we already know because she published a book and she obviously wanted to make money off it. What's the point of writing a book if no one's going to buy it, right? Number 3, that Becky Hill neglected her duties and office to promote her book. So she's sacrificing her position, saying basically something along the lines of, or doing something along the lines of not performing her duties as clerk of court in exchange for being able to benefit personally from the sale of the book or using information to promote her book. Number 4, Becky Hill misappropriated funds. So again, hypothetically speaking, let's say she did something along the lines of using funds from the state in order to promote her book, for example. That could be, these two could be very related, for example. Like all of these are related, but these two specifically, just a hypothetical. But that would make sense. I wonder what it is, though. And number 5, use the county courthouse to engage in commerce. Now, this one's a little bit more vague, but basically what this means is she used not only her position, but she used the building that she's supposed to just be a clerk in to also try and promote her book. It can go so far as to simply walk around and say, oh, by the way, I wrote a book. I hope that you know about it. to like the judge, other clerks, people coming and going. Like, hi, I'm here to reinstate my license. Yeah, absolutely. Here, let me make sure that you get your new license, sir, or ma'am, or whatever. And Becky Hill pops her head in. Don't forget to buy my new book. You know, that would be engaging in commerce in a county courthouse to a stranger who's just coming in to renew their license. That would be enough. And that right there is an abuse of power, abuse of her position, and abuse of her abuse of office. SLED, acknowledging its agents are investigating Hill for possible self-enrichment at the expense of Colleton County taxpayers, represents a significant escalation in the severity of outcomes for the clerk of court. Absolutely. I mean, tampering with jurors is bad enough, but if you're using your office for personal gain, not only is it like, first of all, if I were her, I would have already resigned by now. I don't know why she's not. Again, I think she feels like this is all going to like blow over, and she's completely wrong. If she had resigned by now, when this all came out, I think she would have been in better footing. I mean, I can't even imagine Becky Hill having to step foot in this office every day since then and having to confront these people. I mean, to deal with them, to look them in the eye, look them in their faces, talk to them. I don't understand. Like, what is holding her back from resignation? Can somebody enlighten me? Because I'm remiss. I have no clue. In her shoes, I would have resigned by now. Potential ramifications for Hill now rise from ethics fines to include potential criminal charges, suspension from office, and even removal from office by Governor Henry McMaster should she be convicted. I mean, is she waiting? Is she literally waiting for a conviction for this to happen? It is always better to resign than to be removed, because when you're removed, it just looks so bad. It's basically you saying, I'm going to hold my ground until the very bitter end, despite what everyone says, thinks, or does. I don't get it. I don't get it. Does she think she did nothing wrong, Need Scholar? Does she feel that it's all fine and dandy and what she did is within the purview of the rules of ethics of her office? It's disgusting. At the time of this publication, on January 9th, 2024, Hill has not been charged with any crime and remains in office. She has repeatedly denied wrongdoing despite the barrage of assaults on her character and integrity. Confirmation of the second investigation into Hill's actions comes just weeks before Alec Murdaugh is set to receive an evidentiary hearing to determine if he's entitled to a retrial in the state's murder case against him, which is the hearing that we're watching right now and will resume in about 30 minutes. So if you haven't tuned in, it's about to go down. Becky is about to take the stand. That retrial hearing stems from accusations by a small contingent of Murdaugh trial jurors and alternates who told Murdaugh's lawyers post-trial that Hill deliberately, that's a big word, deliberately tried to sway them into finding Murdaugh guilty. And obviously, as we can tell from the quotes that the judge was reading back to Juror Z from the affidavit, I mean, Becky Hill coming into the room, taking the foreperson out, going to a different room and saying things to them for 5 to 10 minutes, having a conversation, and then the foreperson coming back and there's no discussion about what they talked to with Becky Hill. Jesus fucking Christ. That's all I have to say. Larry, could she get jail time? Absolutely. Absolutely. Misappropriation of funds is probably a class B or A misdemeanor, whatever South Carolina does. Let's see. I mean, we can look some of these up. Abuse of power, abuse of office, neglecting duties, misappropriation of funds, and engaging in commerce in the courthouse are probably not felonies. One of them may be, if I were to venture a guess, abuse of power to obtain and release confidential info could be a felony. That's like the most egregious in my opinion. The rest is probably misdemeanors. So could she be looking at jail time? Yes. Absolutely. Three of the 4 jurors Murdaugh's lawyers spoke to said Hill made comments to them during trial, urging them to be suspicious of Murdaugh and not to be fooled, misled, or distracted by things he said or his attorneys brought up. One juror, juror 630, provided an affidavit to Murdaugh's defense lawyers saying Hill even coached them to pay special attention during Murdaugh's testimony to his behaviors and movements. This is notable because Murdaugh's tics and body language were a noted focus of lead state prosecutor Cretan Waters as he cross-examined Murdaugh and later made his final argument to the jury. As such, state prosecutors have attempted in court filings to explain away Juror 630's accusations of Hill jury tampering as misremembered comments actually made by Waters. I mean, that is like, those are gymnastics that take a whole new level. A whole new level. I mean, that is some mental gymnastics that you're trying to like, no. You don't understand. It's not what Becky Hill said to them in a private room that nobody knew about except the jurors and nobody wants to talk about. It was actually Waters during closing, and the jurors are just, they're just making a mistake. I mean, that's gaslighting. That is straight up gaslighting in my book. Two other jurors interviewed by SLED in response to the defense's jury tampering claims also reported Hill saying something to them about body language, according to state prosecutors' own court filings. However, 8 others interviewed by SLED said they did not recall Hill making any such commentary. The evidentiary hearing on Murdaugh's request for a retrial is scheduled for January 29th to the 31st, which is today, tomorrow, and Wednesday. It has been moved out of Colleton County to Richland County as a means of avoiding conflict of interest, obviously, since Hill is accused of tampering with the jury and likely be called as a witness, which we now know she'll be called as a witness in 30 minutes or less. While all this is happening, Hill's son, former Colleton Government Technology Director Jeffrey Hill, is also under indictment by state police on wiretapping charges. So this is interesting. So it looks like the corruption in the Hill family when it comes to government work goes deeper than just Becky Hill. Former Colleton County Government Technology. So he's under indictment. So this is not even an investigation anymore. Jeffrey Hill, former Colleton County Government Technology Director, is under indictment for wiretapping charges. Fascinating. Also, it's an abuse of office, abuse of power, etc. Exactly, Daniel Bockwist. Fruit tree. Good summary. Gunnar, thank you so much. What about the alleged car ride? So that's where I think we kind of all suspect it all happened. Because some of the jurors were questioned about if there were any statements made in the car ride on the way to the scene. Because it's like, there's 12 of them. Why are like 2 of them saying, or 3 of them saying, you know, they've heard the conversation, and 9 of them or 8 or 9 of them are saying, no, we didn't. It's because she separated the parties. The parties were separated at some point. And I think somebody also said that there were 2 jury rooms where they had their breaks or whatever. And she already admitted, Juror Z already admitted that they had discussed the evidence before the case was submitted to them. That's it. That's what somebody said, yes, Gunnar, that there were 2 jury rooms. I don't know. I was there, and I don't remember that, honestly. Oh, no, I thought you were saying the fruit doesn't fall far from the tree. I thought that's what you were referring to. That, you know, 2 peas in a pod, right? Her and Jeffrey. Anyway, there's a lot of analogies we can throw in there. Sources with direct knowledge of the investigation into that case have told News 4 that evidence has shown Jeffrey Hill's spying is directly tied to attempts at gathering information about the ethics complaints against his mother and other internal county discussions, and he would then relay back to her. And you know what? I get it. I mean, you have access to this information. You're the technology chief director at the time. Now you're former. You're trying to help your mother. Disgusting, but I get it. Her son is I'm just trying to help mama. Mama's in trouble. I'm just trying to gather the evidence in any way, shape, or form that I can. I don't know why I'm sounding so redneck, but I guess that comes with the territory of the Deep South. Call me racist, call me bigot. I don't give a shit. It's fucking true. Come on. I'm just trying to help out mama. She's in trouble, and I'm doing everything I can within my purview, my power, and my position. Tell me I'm wrong. Tell me I'm fucking wrong right now in the chat. Tell me I'm wrong. Sources with direct knowledge of the investigation into that case have told News 4 that evidence has shown Jeffrey Hill's spying is direct. Oh, I already read that. Sorry. News 4 has since learned Becky Hill's cell phone line was conspicuously taken off the county's plan and released to her personal control soon after county officials alerted authorities of her son spying on their calls and emails. So now they're trying to hide it on top of everything. So now they're also trying to hide it. So after they're being investigated, now they're trying to hide it. Unbelievable. Additionally, News 4's sources says when SLED obtained a warrant to seize Becky Hill's phone as part of the investigation into her son, she reportedly provided agents with a different phone than the one she was originally given by the county. So now she's playing the bait and switch, the switcheroo. Good God. Good God. All right. This is from Fitz News. I got a chance to see him. I didn't get a chance to talk to him when I was over there, but he's a stand-up guy and a reliable source. He writes, in late November, our media outlet published one of its initial in-depth reports detailing the escalating investigation into embattled Colleton County, South Carolina clerk of court Becky Hill. That story, derided by many as fake news, laid out some critical components of this still unfolding narrative. First, our report revealed that Hill was the focus of two separate South Carolina State Ethics Commission investigations, which we have subsequently covered in much greater detail. Second, our November 27, 2023 report was published just days after reporter Andy Fancher exclusively reported that Hill's son, Colleton County Information Technology Director Jeffrey Hill, has been arrested on one count of wiretapping for having willfully and feloniously intercepted electronic phone communications. So he's under indictment. And by the way, for those of you not familiar with the criminal justice system, indictment implies felony. Indictment implies felony. So if you are indicted, you are only going to be in circuit court. Misdemeanors you don't get indicted on misdemeanors. At least not in any state that I know of. I know some states give you like a preliminary hearing on misdemeanors, like Tennessee does, even though it's not a felony. Like in Kentucky, you can only get a preliminary hearing if it's a felony case. And thank you guys for all your emails. I will check those in due course. So if you have, if you need help, if you like legal assistance, stuff like that, that I or somebody on my team or somebody that I know can assist in, feel free to shoot me an email like those three lovely individuals just did. Thank you so much for those emails. I will review them in due course. Obviously, it's a little difficult to do while I'm still live, but I can't split my attention. I wish I could. I wish I was an amoeba and I could just like and like separate myself into two people, and one person is going to be here and one person is going to be there. Maybe I'll get an assistant one day, and that would be I'll be able to do two things at once. But unfortunately, I'm not able to do that. In his report on Jeffrey Hill's arrest, Fancher noted that Becky Hill was forced to surrender her phone to SLED upon the instance of a search warrant. Our late November report further linked Becky Hill to the investigation into her son and noted that investigators with the South Carolina State SLED were exploring destruction of justice charges against both Becky Hill and Jeffrey Hill as it relates to the mushrooming wiretapping scandal. We now have additional information related to these obstruction allegations. First, though, why does Hill's story matter so much? Because in addition to the multiplying myriad of scandals she has stumbled into over the last few months, she remains the focus of a jury tampering investigation, which we are watching today, which many believe will result in a new trial for convicted killer Alex Murdaugh. Hill's office was responsible for the administration of Murdaugh's double homicide trial in Walterboro, South Carolina last year, an international spectacle dubbed the Trial of the Century in South Carolina. So I guess Johnny Depp and Alec Murdaugh are competing for the Trial of the Century title. I guess one could be the criminal trial of the century. The other could be the civil trial of the century. You know, why can't we have both? I think we can have both. We can have the criminal trial of the century of Alex Murdaugh, and we can have the civil trial of the century of Johnny Depp. I don't see Johnny Depp versus Amber Heard. I don't see a reason why we have to pick and choose. You know, we can have two. In fact, it was Hill who announced Murdaugh's guilty verdicts to a waiting world on March 2nd, 2023. And let me add my own little editor's footnote, to a shocked audience, at least on my part, and Danny On was with me. So we both were absolutely floored when she read those words, that he's guilty, that they found him guilty. 6 months after the trial, though, Murdaugh's attorneys accused her of tampering with the jury and engaging in an alleged conspiracy to have a juror believe to be favorable to Murdaugh removed from the panel. That's the egg lady. Murdaugh's attorneys, led by Putin Griffin, accused Hill of betraying her oath of office for money and fame, allegedly influencing the jury against Murdaugh in an effort to sell copies of her book, Behind the Doors of Injustice. I'm sorry, Justice. That book, incidentally, is at the heart of one of the ethics complaints Hill is facing. Hill has steadfastly denied the tampering allegations, including in an affidavit submitted by the state opposing Murdaugh's bid for a new trial. However, she and her supporters have been ensnared in a web of lies, and her book is currently being taken off the shelves after Hill admitted to plagiarizing portions of the text. She even plagiarized? Like, are you kidding me? Like, how deep? How deep does this go? I don't understand. Like, pick a horse and sit on it. I mean, if you're going to be corrupt, just be corrupt. If you're going to plagiarize, just plagiarize. If you're going to lie, just lie. If you're going to steal, just steal. You can't lie, plagiarize, steal, and be corrupt all in the same time and expect to get away with it. Have you never heard the old adage of don't commit a crime while you're committing a crime? You know, like if you're intoxicated, like don't speed. Again, I'm not trying to teach you how to get out of crime, but like it's common sense. If you have drugs in your car, don't go above the speed limit because you're going to get pulled over and they're going to find the drugs. This lady is like committing a crime while she's committing a crime, while she's committing another crime, while her son's committing a crime in order to allow her to commit another crime while she's committing a third crime or a fourth crime or a fifth crime. I'm losing track. I'm literally losing track. And while she's plagiarizing. Sorry, forgot about that. Oh, does anybody have a copy of her book, by the way? I want a copy of her book. I don't know if I can buy it anymore since it's been taken off the shelves. I should have gotten it when it was coming out. That's my fault. I'll literally pay you double. I don't care. I just want a copy of her book. The tampering allegations are the focus of a retrial hearing scheduled for later this month in Columbia, South Carolina, before former Supreme Court Chief Justice Jean Toll. So for those of you wondering how to spell her name, this is how you spell her name, Jean Toll. In the meantime, though, the case against Hill is progressing, including some disturbing new revelations about the alleged destruction of evidence and other attempts to pervert the course of justice. While Hill's recently released Colleton County emails have become the central focus of the story, we have heard little about the cell phone records sought by investigators back in November in the aftermath of her son's wiretapping arrest. According to our sources, that's because the phone Becky Hill surrendered to SLED, an iPhone of dubious evidentiary value, remains the focus of an intense ongoing debate between agents and her attorneys. So she is now trying to like dupe them into giving them a false cell phone that is not the cell phone that was issued by the county clerk. Like, how are you kidding me? I'm going to link, by the way, for those of you who want to read these articles, if you want to read these articles on your own devices at a later date or whatever, they're going to be linked in the description below. So I just updated that. So if you want to read them, you're more than welcome to at some later time. This is Becky Hill. As previously reported, the iPhone Becky Hill surrendered to SLED is not the phone she used during the trial, nor is it a separate iPhone Hill has been reportedly been used since the allegations against her son were made public. Sources familiar with the inquiry. So by the way, a bait and switch, that's tampering with physical evidence, and that's a felony as well. So she may be facing a third charge, tampering with physical evidence, by providing a false, interfering with police investigation would be another crime she can be charged with. Tampering with witnesses, tampering with jurors, tampering with physical evidence. I mean, these are all misdemeanors and low-class felonies at worst for her, depending on what South Carolina deems them. Juror Z said Becky and jury influenced her decision. Thank you, Della Sandor. That's number one. Number two, if Becky said one thing about the retrial, that means new trial. I'm sorry. If Becky said one thing about about the trial, that means new trial. Absolutely agree. Number three, two jurors confirmed this. We have Z and P as in Paul. Number four, the jury discussed the trial prior to, I'm going to finish your sentence, prior to all the evidence being submitted to them during the breaks. And juror Z admitted to that. Absolutely. Yes, that's exactly where we're at. Thank you for that. That was a phenomenal summary. I could not have done it better. So thank you for that very much. Sources familiar with the inquiry indicated Hill switched from a Samsung device to an iPhone in the days immediately after being accused of jury tampering in the Murdaugh case. Suspicious. Where is the Samsung phone used by Hill during the Murdaugh trial? Nobody knows. Agents specifically sought the Samsung device, but as of this writing have not located it. They want the Samsung. No shit. A source familiar with the inquiry told us. The search warrant specifically requested the Samsung. Nobody knows where the Samsung is. Which iPhone did Hill surrender? Again, it's not immediately clear whether SLED obtained the iPhone linked to Hill's original county-issued phone number, which she has since abandoned, or the iPhone linked to the new number she has been using since the scandal broke. By the way, we're T-minus 15 minutes from Becky Hill taking the stand. So buckle up. Buckle up, Dorothy's. It's about to go down. We are not in Kansas anymore. We're still in South Carolina. Anyway, jokes aside, here's where it gets trickier, though. Hill hasn't only been swapping out devices and phone numbers in the aftermath of the trial. She's also been moving wireless accounts, or rather her son has been moving them, hence the wiretapping charges. As previously reported, Becky Hill's county-issued cell phone number was reportedly released from its taxpayers-funded Verizon account and added to her personal account. This, we were told, was part of an effort to evade accountability, specifically to dodge a looming subpoena from the State Ethics Commission for her cell phone records. We have since confirmed, wow, that's a big word, confirmed this switcheroo of Becky Hill's phone line was requested by her son, Jeffrey Hill, on July 24th, 2023, and effectuated 2 days later. Records show that on July 26, 2023, this line was transferred from Colleton County to a Yahoo email account linked to Becky Hill. Of interest, Hill reportedly told investigators on multiple occasions that she did not keep the county-issued Samsung phone after she transferred the line from the county. I call bullshit. I call complete and utter BS. She did, she's lying, she's hiding it because it's got incriminating evidence. Case closed. She was saying she was no longer using the county equipment, one source told us. Her whole story was that she didn't keep the phone when she left the county plan. Clearly, she was until September 5th, which, of course, was the day Murdaugh's attorneys accused Hill of jury tampering. Surprise, surprise, surprise. At the same time, he was switching out his mother's cell phone account in late July. Mysterious things were happening with Jeffrey Hill's two phones. A Samsung device linked to his personal number and another Samsung device provided by the county. According to sources familiar with the status of the investigation, Hill ordered a new Samsung phone for use on his county-issued line on or about July 18th, 2023, and disposed of the county-issued Samsung phone he was previously using. What happened to that device? It was destroyed, we are told, and thrown into a dumpster. Why did Jeffrey Hill allegedly throw away his work phone and transfer his mother's county-issued phone line in late July? Because, according to our sources, that's when he realized he had been caught wiretapping Colleton County Deputy Administrator Megan Utsi, purportedly as part of an effort to keep Becky Hill abreast of the investigations into her conduct. So once you realize, oh, you're being investigated, let's destroy the evidence. I mean, this is literally hook, line, sinker. Jeffrey Hill was suspended on July 27, 2023 for wiretapping Utsi the day after his mother's county-issued phone line was officially transferred. He returned to work on August 14, 2023. In other words, it would appear he got rid of his original work phone just in time. What a coincidence. What a coincidence. 3 weeks after he was reinstated, the jury tampering allegations were levied against his mother, prompting a dramatic escalation of the situation. Within a week of those allegations being made public, on or about September 11, 2023, SLED sought to interview Jeffrey Hill related to the wiretapping allegation, which is when he allegedly destroyed his personal Samsung cell phone. According to our sources, Hill destroyed his personal Samsung phone the moment he learned SLED wanted to interview him. He definitely knew that the walls were closing in, one source told us. Jeffrey Hill's new county-issued Samsung phone was surrendered to SLED upon his arrest. According to our sources, the device obtained by investigators had been factory reset, which means the company completely erases your personal information and data to make your phone or tablet a clean slate. And by the way, is there a way? Oh, you want to see Jeffrey's pic? This is Jeffrey. I'm sorry, I kind of skipped over it because I don't know. It doesn't fascinate me. But that's what he looks like. Doing a factory reset on the device. Jesus Christ. I need to stop saying those words. I know somebody already called me out in the chat earlier. I don't know. I just use it as a shocker, you know, when I'm not impressed by something. But some people may take offense to that, so I get it. It won't let me zoom in. My thing is frozen when you refresh. Here we go. Okay. Jeffrey Hill's new county, where are we? Yes. Jeffrey Hill's new personal Samsung phone was also surrendered to SLED upon his arrest on November 21st, 2023. This device had also been factory reset. 6 cell phones, 2 of them allegedly destroyed, 2 of them factory reset, 1 reportedly missing, 1 which investigators have in their possession, but is clearly not the device they sought via their subpoena. Frankly, this alone constitutes a compelling case for alleged obstruction of justice on the part of Becky Hill and her son. Not only that, these evasive measures appear to have taken place at pivotal moments in the evolution of this story, i.e., when Jeffrey Hill allegedly became aware that he had been caught eavesdropping on Utsi when the jury tampering allegations against Becky Hill became public and when Jeffrey Hill was first contacted by SLED about an interview. Even more problematic, we have received troubling reports that SLED agents and officials sought at various points during the investigation to downplay any possible connection between Jeffrey Hill's eavesdropping on Utsi and the ethics investigations into Hill. I mean, naturally, when you're trying to hide everything. That kind of makes sense. We are continuing the probe. We are continuing to probe the evolution of this inquiry and will provide updates to our audience, including a more detailed discussion of SLED's role in this investigation. As of this writing, Becky Hill's cases remain with the ethics investigators, although we have been told to expect a criminal referral at some point soon. Meanwhile, the Attorney General, Alan Wilson, whose office prosecuted Murdaugh, has accepted prosecutorial jurisdiction over both Becky and Jeffrey Hill's cases, but has yet to say whether he's referring either matter to a non-conflicted solicitor or whether he is assigning them to a statewide grand jury for further investigation, as has been requested. And this is Fitz News main dude. He was at the trial. I remember seeing him. I think James talked to him. James from court, which, by the way, I wonder what he's up to and where he's at right now. But yeah, that's Becky Hill. For those of you who don't know what she looks like. Son is an IT expert, says Delasander. Fake Facebook account to get Egg Lady off the jury. They did get the Egg Lady off the jury, and she was allegedly going to vote not guilty. And I think they had some evidence of that, and that's why they took her off. Yeah. Check her Google reviews. Oh, now I'm curious. Wait, how do you look up her Google reviews? I looked up Colleton County. Oh, here we go. I don't see anything of value. What am I missing? What am I missing, Marty? I do have PayPal. What are you trying to send me? Trying to send me some moolah? Here's my PayPal email. Hello, Jonathan. Hi, Edgar. Thank you so much. Yeah, I blocked him, Jim. Thanks for calling that out. Okay. Oh, by the way, Sophia, I don't know if you are privy to the latest. So that deal is now off the table. We're not going to talk about it because I don't want to, but that's it. There is no more money on the table for anybody. I am happily in a relationship, so I appreciate everybody looking out for me, but this thing evolved way faster than I ever expected, and I'm happy. So that's all we're going to say about that. Someone in the chat was asking for gas money. Really? That's just lame. But yeah, I made a follow-up tweet literally yesterday that's it. I'm hitched, and that deal is off the table. No, I mean, but it's legitimate. It's a legitimate question. It's a legitimate question because just 2 weeks ago, I offered a bounty. I did 100%. I've never done anything like it, and I thought it was a stupid idea, but I went for it. It is what it is. I already answered this one. So in about 2-3 minutes, Becky Hill is going to be taking the witness stand. Are you all excited? Nervous? Both? I know I'm both. Becky Hill book. What's the name of her book? Behind the Doors of Justice, right? Let's see. Behind the Doors of Justice. Oh, here she is. I'm going to leave the sound on of the court. We're not quite back yet, but I do want to. Let me show you guys this. This is a month ago.
New twist in the case of Alec Murdaugh, the disgraced South Carolina lawyer who killed his wife and son. The outspoken
Allegedly.
court clerk now under fire after writing a book about the trial and the Murdaugh family. Trevor Ault has the details. Trevor, good morning.
Good morning, Whit. So this county clerk in Alec Murdaugh's murder trial had already been in the spotlight. His attorney said she tampered with the jury, which she and prosecutors deny. But now there's this new controversy. She wrote that book about the trial and now seems to admit that some of the words in that book were stolen.
This morning, yet another twist and scandal surrounding the trial of convicted murderer Alec Murdaugh, once again centered around the county clerk who read his verdict.
Guilty, guilty, guilty.
In the aftermath of that bombshell trial, Becky Hill co-wrote.
We're back. We're back in court. Oh, why is this so choppy? Let me refresh. Wait a second. Why is it so choppy? Is it choppy for you guys too? It sounds like the sound is kind of really choppy.
All right.
That's really annoying.
Is state ready to proceed?
Ready to proceed.
Oh, for God's sake, come on.
Very good. We certainly will wait on that, Mr. Harfootman.
Your Honor, once he's seated, I have a matter I need to put on the record.
All right, sure. Yes, sir.
Your Honor, we last week discussed the standard by which you would proceed during this proceeding and evaluate the evidence. We argued that you should use a case called Bremer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant to show certain statements were made or certain conduct happened. So far, Your Honor has called as court witnesses 12 witnesses. We were not offered the opportunity to cross-examine them. And so we've not had the opportunity to present any evidence whatsoever. And before the state presents evidence, I believe that we should be able to call witnesses. And I would ask the court to allow us to present some evidence before the state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point, So I would ask you to allow us to call a witness or two before you make a decision as to whether or not they need to call a witness.
State?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's what we're doing here, that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with the jury to present the normal criminal trial process. This is a inquiry that is very much directed by the trial court and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. My understanding is, as far as putting up Ms. Hill, this is the manner in which the court wanted that evidence presented. And so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with the manner in which Your Honor's proposed to conduct it.
Please, the court, Your Honor. Certainly, the conduct of this hearing is within your discretion. What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state is required to present evidence to contradict that evidence, or in some way, I'm not quite sure, since Remmer is not the standard, I'm not quite sure what they have to prove. But that's an argument down the line. I believe we ought to be able to call witnesses now. And we have witnesses which would substantiate the burden we have to show you that statements were made by the clerk of court, and that those statements had impact on a juror or jurors.
All right. I've got a couple of reactions to that. Number one, the pretrial was the time to figure out exactly what we were going to do here. And I think it comes at the last minute for you to now come and say, we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call, other than this lengthy filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. Second thing is, I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say were said, she says were not. So there's a conflict in the evidence there. I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards, we can talk about whether there's any need for any other witnesses.
Your Honor, just factually argue this with you. We did not understand. We assumed you'd adopt Remmer because that was.
Well, I don't know why you assumed that,
because
when the
that's
South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of U.S. v. Remmer.
That we do not believe that's what Justice Kittredge has said.
They said it straight out, as clear as a bell can be, but I ruled on that.
Yes, ma'am.
And,
all I'm saying
and the South Carolina Supreme Court's going to have plenty of chances to decide that they want to modify Green.
Well, when we were somewhat taken aback by a ruling as a result, and that ruling came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry? This gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair trial.
Totally agree. Made before this time, Mr. Mark. Well, Mr. Harper, I've told you how I'm going to handle this thing. Your objections are noted and they're on the record. But right now, what I'm going to do is what I said I would do. We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yes, Your Honor.
All right.
Just let me bring it to your attention this email.
Just one moment. Let me go to a little something here that I'm just getting an email on and put this on the record right now. I have a communication from Mr. McCullough
And our team today.
that's only, that is copied to Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson. And basically says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at it.
What?
I want to hear from the state and the defense, but I can tell you, I'm not inclined to get back into the testimony that's already been taken by these jurors.
Excuse me?
Her inconsistencies, whatever they are in the record, and she now wants to have another bite at the apple. I'm not at all enthusiastic about that, but I will hear from you, Mr. Waters, first.
Your Honor, the jurors testified, the court conducted the inquiry that needed to be conducted. She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. So we believe we should proceed forward as the court's indicated.
Oh my God, this is just getting messier and messier.
Harpootlian?
Your Honor, I note two things. The first thing is we asked to be able to examine this juror. You denied that request. Number two, she's not our witness. She's not Mr. Waters' witness. She was the court's witness and a juror that, and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is.
So we'd ask you to make it a part of the record. You can say you're going to consider it. You're not going to consider it, but it should be a part of the record.
Well, I'll give some thought to whether this thing should be a part of the record, but I can tell you this. Witnesses don't get on the stand and testify under oath and then seek to add or change or deal in any way with their testimony. Those questions were very open-ended questions that asked for her responses, and she gave them. If they're inconsistent, she can't come up now and try to close the loop of consistency by some additional testimony. And I am not thinking about allowing that to be done.
All due respect, Your Honor, we believe, and we said at the time,
I
the
see
way
her
you
point,
questioned her
but
put her in
still.
a position of saying, yes, that was my verdict then. We think, and we couldn't examine her. And Your Honor, to say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I note your
She's going to deny the new
position
trial.
on that matter.
She's going to
but I
deny the new
find
trial.
that- All right.
We'd make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I have looked at it just in the moment right before I put it on the record. I'll do some research about that, and
I'll do
close
some
that
research
loop
about it
before
so she doesn't even know the
today.
answer. Admit it. That's good.
Okay, we
I
have
like
2 more
that.
days. We don't have to wrap everything up today. Thank you.
Yes, sir. All right. Mr. Waters.
Thank you, Your Honor. The state calls Rebecca Hill.
Okay, so real quick, 2 things about that.
Bring it to the court.
I understand. She probably consulted with her lawyers and they were like, I'm sorry, I forgot to say this, and this. She wanted to take the stand again, juror Z. The judge, I understand her position because now it's like you've already consulted somebody. You can't take the stand and change your testimony or whatever. But it's frightening. These are jurors. These are not just regular witnesses who are like privy to a crime or witnesses to a crime. They're jurors. They're terrified. They're scared. They don't know what's going on. This has never happened before. This is terrifying. She wants to clarify an answer. Let her fucking clarify an answer. This is unprecedented stuff. You're setting the bar so badly, Judge. Let her take the stand. I'm sorry, I had to have done that. Thank you for being a member for 13 months, CBC. Here we go.
I do.
Thank you.
Good afternoon, Ms. Hill. How are you?
I'm fine.
I want to get started, if you would, if you could state your full name for the record and spell it for the court reporter, please.
My name is Becky Hill, last name Hill, Hill.
All right. And if you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk of court?
At the end of 2020.
At the end of 2020?
Yes.
And prior to that, did you have any involvement or experience with the state judicial system?
I did.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you would serve in the courtroom, which is Ms. Harris is here today, is that correct?
That's
what
correct.
Was your, and was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
Did you have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher, and I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury, and the attorneys will state their opening argument, their opening statements, their closing arguments, and basically
Wishy-washy answer.
The clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like
that's
that, just
her
to make sure
defense.
that they're taken care of.
Is it
She's
common
taking
for
care
courts
of
of
the
court
jury.
to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes,
And did that happen in the Murdaugh case?
it did.
And can you give us an example of some of the logistical things that you or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were
Objection
comfortable,
leading.
things like that?
Objection
Yes,
leading.
all of that.
Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County, yes.
Did you provide them with
Objection leading.
aspirin or Tylenol if they needed, make sure coffee and
Objection
snacks
leading.
were available?
Yes,
Did you take lunch orders for them
Objection
so that they
leading.
were fed each day?
yes.
At any time, did you interact with any juror in an attempt to influence their view of the facts in the State v. Murdaugh case?
No,
All right. Now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No,
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
no,
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
Let me ask you if you ever made any comment to the jurors about the fact that the defendant was going to testify. Did you have a conversation in the presence of the jurors prior to the defendant testifying about the fact that he was about to testify?
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury. And
Bailiff foreman.
I was
She
talking to
accidentally
him
made a
about
slip.
that.
All right. And
She
what did you say?
slipped. That was a
I told
Freudian
him
slip.
what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill.
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in, which would prolong the testimony in the trial a little bit, and also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day? Pay attention. We'll get coffee for you. Things like that during that?
I usually give a little pep talk to the jurors. It's sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention. It's a big day today. Whatever you need, let Mr. Bill know, or one of the other bailiffs, and they'll be glad to get it for you.
Did your comments, or were your comments in any way phrased in favor of one side or against another side, or were they more of a neutral comment about paying attention?
No, it was not for one side or the other.
Objection, compound question. She didn't answer the second portion of the question. She just answered the first part. Hello? Hello? Anyone? Anyone? Bueller? Anyone? Defense is asleep at the goddamn wheel.
Were you present when the jury went to the Moselle property to conduct the jury view?
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
During the course of this trial, did you have a bailiff employee whose primary job it was to see to the jury and their security and keep them separate from everyone else that was involved in this trial?
I did.
And who was that?
Mr. Bill Polk.
All right. And he was ultimately the jury coordinator in this particular case?
That's correct.
During the course of the deliberations, once the jury went back there, did you have any contact with the juries or have any substantive discussion with them?
Not at all.
Did you have any discussion with them about logistics, about staying in a hotel or anything like that?
I did not.
Did you have any interaction with the jurors or anything to do with them having smoke breaks or anything like that?
I did not.
I'm sorry about the choppy audio, you all. It's nothing to do with me. This is Law and Crimes footage. I have no control over it. I apologize. So bear with me. I'm suffering just as much as you are.
During the course of the trial, did you have any discussion or interaction with the jurors about them giving any interviews to the media or making themselves available to the media? I'm asking during the course of the trial.
No, not during the course of the trial.
After the verdict had been reached and the case was in sentencing, did you have any conversation with any jurors at that time after they had already entered their verdict and been individually polled?
Yes, after the sentencing.
All right, and tell the court what that interaction was at that time.
There were several outlets, news outlets, that wanted to interview the jury as a whole and really wanted to get them up to New York. And so I was trying to get a hold of all the jurors to talk about that.
Oh,
that was something
why?
we were not prepared for.
Did you
Yeah,
at all
because
pressure
your
the
shit
jurors
is about to leak
speak, or
out
did
and you were
just
scared.
tell them that it was their option to speak or not, and here's the contact information?
I did not pressure the jury to speak. No.
Did you advise them that it was their decision and their decision alone whether or not they wish to speak to the media?
It was totally their decision.
And did you advise them of that?
Yes, yes.
You needed to cover your tracks, huh, lady?
I'm going to ask it again, but I just want to be sure. At any time, did you make any comment to any juror or in the presence of any juror in which you at all tried to influence them in favor of one side or against another?
I did not.
Did you understand, being a longtime court employee and clerk of court, that that is outside the boundaries of what is appropriate interactions with the jurors during the course of the trial?
Absolutely.
And at any time did you violate that rule that you understood?
I did not.
Court's indulgence, 1 moment.
I don't believe her. A juror would never say something like that unless it happened. I just don't believe her.
Nothing further at this time, Your Honor.
Please, Court, Your Honor.
Mr. Harpootlian, on cross-examination.
Here we go. This is your time to shine, Poot. Make it work. Make us remember this. Make us remember this moment, Poot. Don't let me down.
Ms. Hill, we spent 6 weeks together, didn't we?
We did.
And during those 6 weeks, you were as helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Thank you. Wait.
What is that noise?
Where were we? Oh, yeah, we're old friends.
You heard, that was the microphone that was supposed to, you're fine where you are, absolutely fine.
Yes, ma'am. It was a staged microphone that was obscuring my ability to question the witness.
Yeah, well, what I'm wondering is whether you can be heard without a microphone. Do we need to try to get a microphone up on this podium? Yeah, that would be good.
Becky's anxiety broke the microphone.
All right.
I don't know who's supposed to hear this other than you, but I assume
Everybody on the internet?
they can hear us.
Hi, Poot.
Court reporter, I'm sorry. She's more important, not as important as you. Your
Yes.
Honor.
More important than the judge? Come on, Poot.
Oh, yeah, we're old friends, right? We spent 6 weeks together in a very pressure-filled situation, correct?
It was a long 6 weeks.
It was a long 6 weeks. And during those 6 weeks, you were helpful to me in a number of different ways. accommodating friends that I had that wanted to come watch the trial, for instance, correct?
That's correct.
You even allowed me to use the private restroom down on the first floor so I didn't have to stand in line with the rest of the people trying to get breaks, correct?
Correct.
So we have no animosity towards each other. You didn't do something to me and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some questions
I'm
today
about to do something to you now, though.
that may indicate to you that I have some
that's what I was thinking
antagonism
you.
towards you.
Really
Let
like-
me disabuse you of that. I'm here doing a job representing my client. And you've been around the court system for decades, correct?
Yes, sir.
So you understand what we're doing here today.
Yes.
Now, let me understand a couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Your Honor, objection. I believe, I would object to relevance. I believe any draft she sent to her co-author with the book is beyond the scope of this inquiry here today.
Overruled. You may proceed.
Thank you, Your Honor. And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing. Is that correct?
I would agree with that.
Okay. Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
I'm so disorganized, I apologize. Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
And were they there with you the entire 6 weeks?
No,
I mean, how long were they there? How often were they there?
Rhonda McElveen was there as often as she could be, probably several times a week. Renee Elvis helped me during the jury selection.
And did she begin, that is, Ms. McElveen, did she begin working with you prior to jury selection?
Can you repeat that question?
We began jury selection, I think, on January 23rd, correct?
Correct.
Was she working with you or consulting with you prior to the 23rd?
No, sir.
Did you have any conversation with her about the trial?
Not until she got to the trial on I can't remember the exact day she came.
Okay. Now, is she a friend of yours?
She was a friend, yes.
Was?
Well, she is a friend.
Okay.
Yes.
She's done nothing to make you any less a friend.
No, sir.
Now, did you tell her about the time of the trial that you were going to write a book? That you had thought about and were going to write a book?
I can't remember exactly. I think we did have a conversation about a book possibly in the future.
And did you tell her you're going to write a book because you thought it would make a lot of money?
Oh, no, sir.
You never said that.
No, sir.
And did you tell her that you were going to write a book to make a bunch of money so you could buy a lake lot? and build a house on it?
No, sir.
Okay. Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
Right. That you and he took a juror home one night? Did you tell her that? Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Polk and you take a juror home one night?
No, sir, we didn't.
Okay. You never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Okay. Now, also, during the trial, your daughter ended up on the Venari, is that right?
She did.
And she was coming up, and did you talk to me and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror. Did you not?
I remember you asking.
Okay. Okay. I was considering putting your daughter on the jury.
Yes, sir.
And who does she work for?
She works for Compass South.
Did she work for the sheriff's department at some point?
No, sir.
Okay. Did she work in law enforcement at all?
No, sir.
Okay. Now, let me ask you this. How many jury rooms were there?
We have 2 jury rooms in Colleton.
In this trial, how many jury rooms did you have? How many?
2.
Okay, so the entire jury wasn't together at any one time? They were separated into 2 rooms?
Yes.
Okay. And when they're separated into 2 jury rooms like that, are they next door to each other? Are they down the hall from each other?
They are next door to each other.
Okay, so but if you close the door to one, can they hear what's going on in the other one?
Some women probably have very good hearing, and men too, but I would say probably not.
Okay, are there restrooms in both of the jury's rooms?
There are.
Okay, are there 2 restrooms or just one?
There's 1 restroom in each jury room.
Okay, were either one of those restrooms designated men and women, or did everybody use the same one?
They were unisex.
They were unisex. Okay, now, prior to your testimony here today, have you met with the Attorney General's office in SLED?
I have.
On how many occasions?
I want to say twice.
Okay, and remember when the first time was?
I think the first time was in September.
Okay, and the second time was last week?
Yes, sir.
And that was in Walterboro?
Yes, right.
And y'all spent about 4.5 hours together?
I'm going to say maybe 2 hours together.
Okay. And in those 2 hours, you went over your testimony here today?
They asked me questions.
Did they ever correct your answers or suggest you answered differently?
Oh, no.
No. So you just went through what you went through in 20 minutes here. It took 2 hours to go through when you were with them.
There were times when I would step out of the room and come back in. But I would say we were there for about 2 hours.
Now, you have described in your book your role as Switzerland. Is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial. Is that correct?
That's true.
Okay. Yet in your book, you indicated a number of different points during the trial you had concluded he was guilty. Is that correct?
I think.
Your Honor, I object at this point. I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether or not there was any communications with the jurors, which is the sole issue that we're here for today, is whether or not Ms. Hill had any extraneous influence on the
Overruled.
jurors.
You can answer. She
So
can
I think
answer.
this is going a little far afield. We object to the relevance here.
Thank you.
Let me give you an example. You indicate riding back from Moselle that you and 3 other people were in a car and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will
Did
agree
that
with
happen?
you. We did have a conversation about what each of us thought,
And all four agreed that he was guilty, correct?
and none of us were jurors.
No,
That's not the question,
trust
lady.
me, I know that.
Answer
But
the
you
question.
had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Okay. But the four of y'all rode out there, and based on what, and I mean, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you, or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Right, again, I object to not only the relevance, but the scope of cross. I would object also under Rule 608. I don't believe that's appropriate cross-examination.
Overruled.
Thank
You may continue, Mr. Harper.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr. Hartfield.
that's stealing, isn't it?
And it is, and for
Okay.
that, I'm very sorry, and I have apologized.
I'm so sorry. Oh, please
And that
feel
makes it
bad for
okay?
me.
What I did, and I apologized for
Okay.
that.
And part of the book is, you say, literary license, exaggeration.
I wouldn't call it exaggeration.
Okay. Now, let me ask you this. Is Switzerland, and this is, you're saying this is happening while you're supposed to be Switzerland, you decided the defendant's guilty. And if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the
Oh,
question.
no, that's a
Syntax,
beautiful
not evidence.
question.
Overruled.
Yes, answer the goddamn question.
Can you repeat that question one more
Do you
time?
feel
Mr.
you
Hartfield?
stepped over the line from time to time?
Let me ask you.
No, Poot, don't let it go.
you
Don't
had
let it go.
interactions with
Ask it
some
again.
jurors, and I believe in a conference in the judges' chambers, you indicated that you had seen a post on, is it Walterboro Word of Mouth?
God damn it, Poot.
Your Honor, again, I object.
Ask the question again. Do you feel like you crossed over the line? Yes or no, Ms. Becky Hill?
For Your Honor.
I will allow limited,
Oh my
as I
God.
understand it, trying to impeach her testimony and explore her credibility. And
I can't.
I think I've already told Mr. Harpootlian that I don't want
I'm
to
about
hold
to
trial
I'm about to
the
defenestrate this motherfucker.
Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harpoot.
Ask the question, Poot.
Am I over?
Do you feel that you have
oversimplifying that?
stepped over the line? Repeat the
it's in your
question.
book.
The court gave you permission. Please, for the love of
You
God.
Saw something on Walterboro Word of Mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I
I'm losing my
oversimplifying that?
fucking mind.
I remember reading one night something on Walterboro Word of Mouth, and when I was in the courtroom on a Monday morning, listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
I'm sorry, you all.
She
I'm
was
sorry.
very talkative, and when I was instructed by Judge Newman to go and get her
killing me.
from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers, and she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro Word of Mouth thing?
I let the judge know, thinking that it could be related,
Okay. And you let the judge know what?
that I had read something on Walterboro Word of Mouth.
Okay. And that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who'd you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found what we call the apology post? You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking and he apologized for what he posted? You didn't produce that?
My staff did, one of my staff.
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't?
I don't know that, Mr. Hartbulian, no.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that
I never talked to that juror about stuff like that.
What did you talk to her about then?
Did you ever talk to the forelady of the jury, separate from the jury?
I did.
Okay.
Okay.
And tell us, where did that occur?
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway, in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very, very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was there was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you if some issues jurors had emotionally, or some issues with dissension in the jury room?
She only told me that there were some loud jurors, and it made some of the other jurors a little upset. But other than that,
What did you tell her to do?
I told her if it got out of hand to write a note to the judge, and that she could sign the note and get Mr. Bill to give it to the judge, and the judge would handle that for her.
Okay. Now, you did publish a book after this trial, is that correct?
We did.
And you went to New York and took some of the jurors to the Today Show?
The Today Show did invite us, yes.
Now, one of those jurors that went up there with you, the day of the verdict, wore, for the first time I can remember, wore a suit to court. Do you remember that?
Your Honor, again, I would object to discussion of the jurors wearing a suit or a post-trial trip to the Today Show. I don't believe there's any connection to the inquiry that's focused for Your Honor, and that is whether or not there was any extraneous influence during the course of the trial.
I'm going to connect it, Your Honor.
All right.
Thank you.
May continue, Ms. Hubbard.
Did you text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it'd be over by the next day? It would be, the jury would not be out very long. Did you ever communicate that? Email, text, or verbally?
I do remember saying that, yes.
And why did you think the jury would not be out very long? Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress. And it's a guess. It's a gut feeling. And that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that.
Would you refresh your recollection if I showed you the email?
You know, if he wanted to come, I knew that the trial would be ending shortly. as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press and others that there'd be a quick verdict. Were you not?
That was just a gut feeling that I had. And that was my opinion.
Your opinion, you were right. Jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
Oh, that's a great question.
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that.
Give us the number.
But I
lady.
want to say roughly around 100,000.
Only.
That's not a lot of money.
Not a lot of money, just 100K.
You know, especially when you publish your own book.
Oh no, you
But that
poor
was the
thing.
100,000 you made.
With my co-author.
Okay.
Oh, you poor thing.
In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. Trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Oh no.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think is kind of what you put. Did you not?
Well, Mr. Hart Hooley and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know, but you believed and you published that the Murdaugh family had run that part of the state and they'd been participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
Objection
He's
overruled.
asking about what she said in the book. I'm going to allow it.
Yes. Sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals? I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? About the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which sells books?
Literary ease. Yeah.
What?
Literary.
Literary what?
The literary ease that you can take when writing a book.
Literary ease you can take with writing a book. You can make stuff up. You can lie.
Oh.
You can lie about people.
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What do you mean by neutering Jim Griffin?
Mr. Hart Julian, it was a book.
Did you make it up? I know it was a book. The Bible's a book. I mean, just because it's a book doesn't mean you can lie in it.
It's just a word. That
Answer the question.
Don't argue with the witness, but the witness, Ms. Hill.
Answer the goddamn question. Yes, thank you.
You may proceed, Mr. Harper.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay, not true based on my experience of being in a courtroom, and not true based on knowing some of the people you described. You say that is.
Mr. Harputian.
I object. The counsel is just testifying right now as to his observations about the book.
Question, Mr. Harputian, please.
You've conceded there are things in the book that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not in evidence.
Compound question. If what you're asking is what she told Ms. McElveen, go on and ask that, but don't precede it with
Yes, Your Honor.
testimony.
Beg the court's indulgence for just a moment.
Oh, this is good. Finally, Poot's on the ball. But he needs to dig deeper. He's just scratching the surface. He's doing a decent job, but there's just so much more that he can dive into. And of course, that one question, would you admit that you stepped over the line? Yes or no? I mean, let her say no. That's fine. What if she says yes? I feel like I stepped over the line a little bit. You don't know. She might throw herself under the bus.
Write your book about that juror, whose ex-husband had posted something we now know probably wasn't her ex-husband. Did she have any other ex-husbands that you found out about?
I have no idea.
Well, you wrote, we learned later the ex-spouses hadn't seen each other in 14 years and she had 3 restraining orders against him. Did she have 3 restraining orders against him?
I don't know. That's what she said.
Okay.
Come on, dude. Poot, don't stop here. Don't let her go. Not this easy. You have so much more. Read lines from the book. Ask her directly. Dissect her. Grab a knife like a surgeon.
Did you tell jurors
and dissect her?
At the end of the trial after President's Day break would have been a Monday, correct?
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Harpootlian, I never talked to the jurors about any of the evidence
The
in this
answer would be
case.
yes or no, then you can explain. Did you say that?
No.
Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
No.
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
To pay attention, not specifically to his testimony. I did tell the jury to pay attention.
To what?
Just generally in the hallway when I was speaking.
Not to him?
No.
Just any witness?
Right.
Okay.
Oh my God.
Did you
No, I would dig deeper. So you did talk to the jurors.
Did you ever
told them to
warn
pay
the
attention.
jurors the defense is about to do their side? This is right before, right at the beginning of the defense case. They are going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Did you ever tell the jury that?
No, sir.
Okay. Did you ever tell the jury, if you get emotional, we want to see your face because that is what they want to see? You ever tell them that?
No, sir.
Did you ever tell the jury that Mr. Murdaugh was about to testify?
I didn't tell the jurors that.
Now, did you tell the jury that if they didn't reach a verdict by 10 o'clock, they were going to have to spend the night?
No, sir, I did not.
Did you ever tell them they were going to have to spend the night at
No,
some
sir.
point? Did you ever tell them that they couldn't smoke?
No, sir.
Okay.
I found it funny that the closed captioning said yes, sir, even though she said
You got
no.
any other books in the works?
Funny.
No, sir.
I mean, doesn't this make a good book?
Answer the question.
Thank you.
Doesn't she? That's what I keep thinking, Gruntamar. Tamer, sorry. She does look like Umbridge. Those of you not familiar, it's the
Yes,
evil
sir.
wench from Harry Potter. I can't believe Pood. Yeah, I agree, Roland. Pood should be arrested for a crime of the worst cross-examination in the history of humanity. He had such a golden opportunity. He has a witness who's lying through her teeth, and he could go so much deeper on every tiny little element, and he chose to just kind of glaze over the surface on everything. On everything.
Matters came up on cross, obviously, that I'd objected to.
I'm losing my mind.
Waive your client. You may reserve your rights to object to the entire line of testimony, but you may offer cross-examination subject to the assertion of your objection about the testimony.
Thank you, Your Honor. One of the things you were asked about is finding this Facebook post, and you brought that to the court's attention after a different issue had already arisen related to a juror. Is that correct?
Correct.
All right. And are you technically capable of manufacturing a Facebook post? Is that anything that you have any capability to do?
Yes.
I'm not.
Yes, you can.
And did you ask your staff member to go see if she could find this post?
I did.
Did you tell her just generally what you recalled reviewing?
Yes.
And did you give her any further instruction other than that?
No.
Were you sitting behind her as she was doing this particular search or anything like that, or did she eventually report back to you?
She is very, very techie. And then she reported back to me.
All right, so you weren't there when she was searching anything like that?
No.
She was like, I couldn't find that post, but I did find this, and handed you the Facebook post. Is that correct?
Correct.
And then you provided that to Judge Newman, and ultimately it was provided to the parties. Is that correct?
Right. Correct.
You were asked about conversations that you had with the forelady. Did those involve logistical issues and things like that for the jury?
The conversations with the forelady was everything. There was nothing regarding the defendant and this trial.
All right. So they were logistical issues, not anything to do with the substance of the trial. Is that correct?
Absolutely. Yes.
You were asked about whether or not you had texted some people, this won't be long. Was that at all in any way based on any conversation you had with a juror as to their internal thinking or anything like that? Or was that just your assessment being an experienced person in the court?
Absolutely not.
It was based on just your assessments?
Just my assessments. Yes.
Did you ever communicate with the jurors on how long they would be, or did any juror ever tell you how long they thought they would be?
I never talked to any jurors about anything like that.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about some of the assertions that you made in the book. And you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
Thank you.
You are
Finally,
leading fine.
Pood woke up.
This is your witness, Mr. Fine.
Good Lord.
Waters.
Yes,
So
thank
please
you.
ask a direct question.
Yeah.
Thank you. Was some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading.
Yeah, exactly.
All right.
Thank you.
He's right about that, Mr. Waters.
Yes,
Just
thank
ask
you.
a direct question.
Did you lie in your book?
No, I did not.
Thank you. You were asked about.
But I thought she just admitted that she did. At least the plagiarism. I guess plagiarism is not a lie.
To pay attention. When you asked that question, did you also mention anything about we got coffee for you or things like that?
I knew that Mr. Bill would take care of that. And the jurors knew too. Coffee, we had done some Dunkin' Donut runs. We had provided coffee, different other things to help stay awake in the cold courtroom that we found ourselves in. And so I knew anything that they needed, Mr. Bill would see that they got, because that's what he did.
At any time, did you have any conversation with any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
Nothing further, Your Honor.
All right.
That's it?
Ms. Hill,
That's it? Where are the fireworks?
I want you to turn your attention to a hearing that Judge Newman had about the alternate who was dismissed, sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
Lay it on thick, Judge. You're the only one who can save us now. Because obviously the lawyers are goddamn incompetent. I'm sorry. This is an embarrassment to the legal profession. And I apologize on behalf of these incompetent lawyers.
In the hearing, Judge Newman expressed his unhappiness with you for questioning that juror before he questioned her. Do you recall that?
I do remember seeing that.
Well, then let's go back and talk about that juror. You on examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Oh,
Your Honor, I did not ask her any questions.
I think the judge caught her on some. Ooh. The judge is literally doing Poot's job for him. Thank God.
The juror was examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
Oh.
I do recall that hearing.
Here
yes.
we go.
And the court
I'm on the edge of my seat.
asked you about, the court asked this juror about postings on Facebook, did he not?
Correct.
And the juror said she gave Miss Becky my full access to my Facebook. I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014. Do you recall her testifying to that?
I do remember that, yes.
And with that, having jarred your memory, do you recall asking her about her husband and his post?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the Walterboro?
She said she never talked to the juror, and we have testimony from the juror that she talked to her.
What was the nature? You read that.
That's Her
Did you not?
jury.
I did.
What did it say?
My memory is a little fuzzy with that, but it was about a ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror. And it just sounded very similar to what I had heard the judge and the attorneys speaking about.
So you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
I'm not saying.
Some kind of conversation went between the two of her for her to know about that post, correct?
That's true. And I'm thinking that it could have been someone, it wasn't me. I just know that it's not me that she talked to about that.
Well, when the judge, the judge was questioning the juror about this, she also said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury room to the back chambers where the judge was, she was very scared. She was talking about the 3 restraining orders that she had out on her husband at the time that they were divorcing. And she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room, to the chambers with the judge.
And in the court, in this hearing now that I'm looking at,
Yes,
that the
tied
court is
together?
conducting, she said, they're asking about this Facebook post, and she said, Miss Becky said she went to look for the post again and that it had been deleted. I don't know who she talked to or anything else, but she said apparently, do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that, and I didn't talk with her about that.
Well, you saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to talk to the judge about that.
The court asked this juror, has the clerk discussed anything about the case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back, and that's when she first told me about it, about this, what we now know was not a post from her husband.
Right.
But you assumed it was a post at the time, and y'all had a conversation about it, correct? Don't just nod. Answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, but it was not me that she talked to.
Oh, yep.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we're all invested in this. My main concern, I certainly would love to, but not love to, but would want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about this juror and whether this was really her husband that put this post in that you talked to her about and apparently talked with the court about at some point. Am I right?
That's right.
And then at the end, the judge said that he was not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
Oh.
And did you pop right up there and say what you're saying now, that you never talked to her?
We never talked about it after that. I wasn't in the room when he said that.
Oh.
The judge brought up another thing right after sentencing that I want to explore with you briefly.
Okay.
One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the 2 decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the?
Remember this?
I'm talking about the fact he alluded to.
That's what the judge is
on
talking
sentencing.
about right here, in case you're wondering.
And said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits. And you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. J. Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Post and Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How'd you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was, all of the pictures were looked at by the court reporters that were there and the lady from court administration, along with someone from my office and Mr. J. Bender, to make sure that everything was done correctly.
What I'm asking is how you handle having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers and then someone, I think, from the state of the Post and Courier, and they were responsible for putting it out on a stream for the rest of the media to
And
access.
would they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on the scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
All right. Finally, you had indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
Correct.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It didn't matter to me if it was guilty, not guilty, or a mistrial.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book, and part of that is because I think it was a guilty verdict.
Well, this is that you were describing a time way before the verdict was rendered.
So you're lying in your book?
When you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you said your eyes met with jurors and others at Moselle, and y'all have an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent.
What?
But at no time did I read or try to read someone else's eyes, and that was just one of those gut feelings that I wrote in the book.
What? Yeah, the judge is not buying it. I take it back. I'm starting to like this judge. By the way, I've been in Switzerland. I've seen Switzerland. Switzerland still has bunkers that nobody has had access to in over like 80 years that may still have gold that's been confiscated from Jews by the Nazis. They refuse to allow anybody to examine their bunkers. Switzerland is the most horrible example you could possibly think.
You wrote in the book, speaking of a time before the jury verdict was rendered, I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up in the community would influence the jury. You wrote that, did you not?
Yes, ma'am.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt.
But I would never. That's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right.
Okay, we finally got an admission.
Those are my questions. Anything further from the state, Mr. Waters?
Yeah, seriously, someone bloody random. Seriously. When the judge does a better job than your lawyer.
Yes, sir. You were asked a number of questions about the interactions during the in-camera proceedings with the juror who was excluded. Were you in the room during the entirety of those interactions, or just were brought in here or there as those occurred?
No, I was only brought in for my asking of my questions from Judge Newman.
And you were asked a little bit about sealed exhibits and about Judge Newman's comments at sentencing at the end of trial. And just to clarify, those were not pictures of any sealed exhibits. It was a picture that someone had taken in the gallery that had actually been disclosed. And that's what Judge Newman was talking about, to your understanding?
That was my understanding, yes.
And then after the trial, there was even a post-trial hearing or some discussion about the fact that some body cam videos had not been sealed, and Judge Newman fixed that problem after the trial. Is that correct?
Correct.
Nothing further, Your Honor.
Just a couple questions.
Mr. Hartwood,
let me understand this correctly. You would agree that you did release all of the exhibits in this case, sealed and unsealed, to the Texas film crew. Is that correct?
No, sir. No, sir. I did not release the sealed exhibits.
What about to Netflix? Didn't you indicate to the judge they'd been mistakenly released and you're getting them back?
As an error before, when we realized everything, yes, those two did go, and Netflix had not even, they said they had not even looked at them.
Did you get them back?
We did get them back, yes.
And what about a Japanese film crew? Did they get exhibits, the sealed exhibits?
They did not get any sealed exhibits.
What about NBC Universal?
No sealed exhibits.
But you do concede that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Whose
listed.
error?
Well, I would say the court reporter didn't mark it on the listing.
Well, why were you so accommodating to these national documentary folks? I mean, is this good for the book? I mean, the more documentaries out there about the Murdaugh thing, the better your book sales are. I mean, there was money in this for you, right? Again, it's about the money, right?
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more HBOs, more Japanese? Doesn't that sell books for you? Didn't you see a financial advantage?
Not at all.
Okay. Thank you. No further questions.
Ms. Hill, you may step down. let's hang on for a moment. Mr. Lewis.
She's using her subpoena. I just wanted to make sure she's not.
Oh, well, I want her to step down. Yes, she's still under subpoena. I haven't heard what's going to be said. Mr. Harpootlian still has some things he wants to raise about other witnesses and so forth. So what I would prefer is that she remain with you, Mr. Lewis, until we see what else is going to happen. You may step down. All right, Mr. Harpootlian.
Your Honor, we've got literally millions of pages of documents in this case. Ms. Miller just uncovered an email relevant to what you asked. We don't have it printed out. But what it is an email from Rebecca Hill to Miho Takachuchi, something. Miho, first name, the Buford McDowell body cam should not have gone to you. Please get rid of it. Do not use it. Judge Newman specifically ordered the body cam not be used if it got out. Apparently, it's still in the videos we were saved. I appreciate your attention. What about what about the other body cam video? We could see on many new documentaries. Can you provide it? It seems the camera was on the other police personnel. I mean, here she's having emails between this Japanese production company about body cams telling them to get rid of it. I think that's important, and I can have a copy of this printed out for you when we get it to a printer for the record.
That would be fine, but do you want to offer it as an exhibit?
I do.
All right, Mr. Waters?
I have no objection. If I could just ask the date of that.
The date is July.
All right, that's one thing. What else? I will admit it. I will allow it. That is a impeachment of her testimony to me that she did not send any emails or release anything. In fact, she changed that testimony on redirect when she said she did, so-called by accident, release some things.
That doesn't appear to be by accident. So we'd like that made part of the record. Secondly, I have sitting outside the courtroom the clerk of court for Barnwell County, Rhonda McElvey. She specifically denied saying certain things to the clerk of court of Barnwell County and denied doing certain things. I think you're going to find her testimony extraordinarily instructive and educational. And it shouldn't take, I would be shocked if it took 20 minutes.
Well, in light of the answers she gave to my questions and some of yours in that regard, I'm going to allow it. Now, I want to know what else we're looking at here.
Do we have only one copy of this?
Yeah, I'm actually, this judge is starting to grow on me too, Alabama Rose. I'm with you. This is starting to get closer and closer to a probably she's going to grant a
I
new
want to
trial.
hand up to you an affidavit from a witness we would propose to provide in addition to
Thanks, Susan. Don't forget to like this video, comment below, subscribe to the channel if you haven't already.
clerk of court. This is a alternate juror, not the egg lady. This is the alternate juror who was dismissed when she was not needed for deliberations. And she is here also ready to testify. And I would expect her testimony would take about the same time as one of those jurors this morning.
Sir?
I would expect her testimony would take about as much time as one of those jurors this morning.
this is your offer in refutation of the testimony Ms. Hill has given today?
She denied saying any
She
of this.
denies saying anything. That's correct.
Yes, Your Honor.
Now, is this juror, alternate juror going to testify?
She's here. Yes, Your Honor. She's sitting.
Well, you just say she's here. She's available.
Yes, ma'am.
All right. Mr. Waters?
Your Honor, a couple things on this particular alternate juror. We've just been handed this particular affidavit. Your Honor, I believe that Your Honor had correctly ruled that the focus again was on those jurors, and the inquiry has been made to those particular jurors. I don't know why we would go into detail with an alternate juror that ultimately did not sit in any deliberations and cannot testify as to any effect on the verdict, which is the ultimate inquiry before Your Honor. And so we would object to this particular testimony as far as it relates to the alternate juror.
Here's the one thing that gives me some heartburn. You can help me with this, please. I stand by the rulings I have made that only jurors can be questioned about the effect on their verdict. And that is why I did not allow the testimony of the egg juror in that regard. He is now offering this testimony, and it's testimony of certain things that were said to the jurors as a whole, rather than just to this particular juror. And I would, as I say, I would ordinarily not allow this, but Ms. Hill testified several times during the course of her
Oh my God.
just concluded appearance that she never told any jurors anything along the lines of what has been asked here, particularly the comments about they're going to say things that will try to confuse you or throw you off, things of that nature. She was asked about that, and she denied she ever said anything like that. So this is an attempt to impeach as I see it, and that's what's giving me a little heartburn about just turning him down flat.
Well, a couple things as to that, Your Honor. First of all, I think that we have some very specific statements and a specific individual that's mentioned here. And so if we're looking at Rule 613B, which is essentially where they're operating, I don't know that there was an appropriate foundation laid as to the specific time and to whom these specific statements were made. I think that it needed to be cleaner with regards to that as to, you know, mentioning this particular person and as much as you can, the time and place and the very specific statements that were made. I think Mr. Harpootlian, again, we had these general allegations and kind of went through those, but I don't know that now that we've just been handed this affidavit, that they were set forth as an appropriate clarity that's required by 613B. So I think there's a failure there.
Mr. Waters, look for a minute at paragraph 3, 4, 5, 6. Seven. Those paragraphs all address things that have been asked her, and they are pretty specific as to time and place. And this, the content of this testimony is an attempt to impeach her, Ms. Hill's testimony. That's why I, as I guess colloquially I said, I'm having a little heartburn about excluding this, is because she was asked directly about these matters.
Don't forget to vote in the poll.
And this testimony would be in conflict with that. It would be permitted to impeach someone.
Right. And Your Honor, I certainly understand the point. I guess I would have just 2 points to that. Number one is that, as we've already talked about, this evidentiary hearing is within your discretion in the manner, particularly when you're talking about jurors and the manner to be conducting that. Now we're talking about putting the juror on the stand and having attorney examination. And I think under the case law, that's within your discretion as to how that inquiry should go, as opposed to were we purely in a trial setting and applying the evidentiary rules. But if we're applying the evidentiary rules, again, strictly applied, I think that I don't know that they have laid the foundation with enough clarity to offer extrinsic evidence under 613B. And that would be our argument there, that we just had generally discussion of some of these concepts, but not the place, time, and person to whom it was made with the specificity that 613B requires. So that would be our evidentiary objection in the event that Your Honor is addressing those. So that would be our position. I do also, before we get started, I do want to go back and address the sealed exhibits issue whenever it's appropriate.
Sure.
It's now, I'm happy to go.
All right, Mr. Harpootlian.
You're
Slow for a minute. I'm turning to Mr. Waters to try to get some clarity about why he objects to this testimony. One is the 613 issue that he's explored, and I understand that. He now wants to say something about the sealed exhibits. So I want to hear from him on that, and then you can reply to both of them.
I'm sorry, Your Honor.
That's all right.
Distracted by Mr.
Sure,
Barber.
I understand.
And, finally, going back to the juror issue, we would also raise 403 as well, just because of the nature of the inquiry that we're here to assess. Going back to the sealed exhibits, I just want to clarify for Your Honor, Mr. Griffin and Mr. Harpootlian were at this hearing. After the trial, there was a release of, and these were publicly filed exhibits, of a number of exhibits. What also got released at the time were 2 body cam exhibits, which had images of the victims at the scene. Those had inadvertently not been marked as sealed exhibits. And ultimately, then we had a hearing in front of Judge Newman, and essentially those were clawed back. And so I just want to be clear that when we're having testimony about that particular thing, as it relates to what Ms. Hill was saying, those were the sealed exhibits that were released. And again, at the time, they had not been marked sealed, and that was sort of retroactively fixed. And then the other issue, of course, is, Your Honor, is again that the issue that Judge Newman was talking about after sentencing was a gallery photo. It was not a what apparently would be maybe a press photo of the exact exhibits. And what we did at trial, and Mr. Harpootlian can speak to this, and Mr. Bender could as well, is at the end of each day, first of all, the sealed exhibits would have a cover sheet or a folder that they would be in, and then they would verify with the parties that these are the okay exhibits, these are the sealed exhibits, and then at that point, after court was concluded, the media would then be allowed to review and or photograph or get copies of the unsealed exhibits. So that's just how the procedure was working at the trial.
That's very helpful to clarify this, because I now see this in perspective that there were that the materials that were photographs at the scene or depictions at the scene of the 2 victims. What you're telling me is that those were inadvertently released after the trial by the, well, it would have to be by the clerk of court. She's the one that had them. And then they weren't properly marked, and they were then clawed back.
Yeah, they were the 2 body cam videos, and so in those videos, it weren't physical images, but they were the body cam videos, and then in those videos, you could see the victims at the scene. Right. And those 2 exhibits, to my recollection, were the only 2 that should have been sealed, but they, in fairness, were not marked sealed, and that's how they got released. The second we realized it was a problem, we took care of it and clawed those back.
That clarifies that issue for me. So I frankly, that puts my mind at ease about what happened there. Now, Mr. Harpootlian, I'll come to you momentarily. Anything else?
No, ma'am, Your
Honor. Okay, now, Mr. Harpootlian.
A couple of things I'd point out. The first is this, in terms of
thanks for joining on as a member, Susan B.
alternate juror. She was interviewed by SLED on video.
Welcome to the channel.
Said exactly the same thing as she's saying in this affidavit weeks, if not months ago. So they know exactly what she said. I can assume they reviewed it. By the way, I asked, basically read from this affidavit as I cross-examined the clerk, and she denied each one of these statements. The second piece of that is this.
I know it's on that basis that I'm even pursuing the idea of your offering something by way of impeachment. So I understand that.
And secondly, as to the sealed exhibits, I think we're going to hear testimony from Ms. McElveen that may elaborate on your concerns based on our interview with her this morning.
All right. Well, here's what we're going to do. It's about 3 minutes of 3, which is when I generally take my afternoon break. I'm going to adjourn the court or recess the court, and we come back at 3:15, and I will allow you to offer Ms. McElveen and the alternate. I want to make it clear that they will be offered on what we've talked about, matters about which Ms. Hill testified that you think are impeached by Ms. McElveen's testimony and that you think are impeached by the alternate juror's testimony. So and the alternate juror's testimony, as I look at it, is the part about which impeachment would lie would begin at paragraph 3. So do you understand what I'm saying?
Yes, ma'am. Can I make you one other offer?
Yes, sir.
Today and today only. Egg Lady is across the street.
Well,
no. If you want to put her on the stand.
No. I've made my position quite clear about that. I think we've got in the record what is needed in terms of what she says, Ms. Hill says, and what Ms. Hill says she says.
I agree. We did not intend on calling her. I just didn't want you to miss the opportunity if you wanted the opportunity to examine her.
Thank you, Mr. Harpootman. All right, court will be in recess until 3:15.
All right, we're on break, folks. We're on break. Oh my God, where do I even begin? There was so much to unpack here. First of all, Becky Hill lied through her teeth. I mean, I think so far this is completely obvious. She knows she's caught. She's caught red-handed, her hand in the cookie jar. She has now conflicting testimony where during the trial she said that she approached Egg Lady and confronted her, and Egg Lady felt very uneasy that the clerk of court is asking her questions about her ex-husband, whom she has a restraining order against, making comments about her position, allegedly, and she gets struck as a juror. And now she says, no, I did not have any conversations with any juror at any time at any point. And the judge is like, wait a second, but this juror said you had a conversation. Oh yeah, she said that. I never said that. She said that, but you never corrected her. I wasn't in the room. What? That's your defense. It's literally it's worse than the Nuremberg. You know, it would be better if she would be like, I'm just following orders. Instead, she's like the Italian mafia. I don't know nothing. I know see nothing. I know hear nothing. I know privy to nothing. I'm not a part of nothing. I mean, Poot did a horrible job, horrible job. He asked a beautiful question. Do you feel like you've crossed the line on occasion or something along those lines? He said, do you feel like you've crossed the line? And there was an objection and the judge allowed him. And then he skipped over the question. He went to the next question. You never, when the judge gives you an open door, you ask a damaging question and the judge allows you, you re-ask it until the witness answers. You ask it 5 times if you have to. And if you saw a judge interrupted him, and she was like, Ms. Hill, you need to answer the question. And she's like, yes, ma'am. I'm sorry or whatever. So that was bizarre. I don't understand why Poot is not like the judge is literally giving him all the rope that he needs in order to hang Becky. And he's like, nah, I'm good. I kind of like Becky. I don't want to destroy her completely. I just want to, poke the bear a little bit. I don't understand. It makes no sense to me why Poot was letting so many things go. There was just like an open invitation to wreck this fool. And instead he's like, I'm just going to be nice to her. I'm just going to tread lightly. I feel bad for her. I don't know what's going through his mind. I have no idea. I absolutely have no idea. And I believe there was a moment where it's like she committed perjury. Again, I don't have a sight to the direct moment, but to me, it feels like if a juror said, Becky said this to me, and this is under oath, Becky said this to me, and then Becky says, no, I never said that to her. I mean, it's a loaded definition of perjury because it didn't come from Becky's mouth. She didn't say, I talked to the juror, and then she said, I never talked to the juror. That would be perjury right there. That would be perjury. If Becky Hill said, I said XYZ to the juror, she says like a year ago, And then today she says, I never spoke to the juror. I never said XYZ. That would be a statement made under oath and a directly contradictory statement made under oath. And those two make perjury. That is the only way you can get perjury. I know people say, like, people like to throw that word around when people are lying on the stand. If you don't have a prior inconsistent statement, then that's not perjury. You can still impeach them, but that's not perjury. Perjury is a criminal charge for two statements made under oath and two are contradicting one another directly. First you said blue, then you said black, and you have no way of correcting it, you know? So that's how that works. That's how it works. People are saying I'm out of sync. Is that true? I don't know. Let me see my feed. My feed looks to be fine as far as I'm concerned, as far as I can see. Is anybody else having those issues?
Chases. We got to unruly.
No, we don't want that. Am I? Yeah, I am out of sync. You guys are right. Let me leave and come back. Give me 1 second. I'll be right back.
Suspects, raw and wild police videos. You should have seen it.
Oh, there we go. Okay. Sorry about that. I don't know what was going on. Am I in sync now? Does it appear like I'm synchronized now? Shout out in the chat. 1 for I'm synchronized, 2 I am not synchronized. Please. Okay. Yeah, I've been streaming for like over 4 hours, so the stream may have lost synchronicity. I apologize. I'm sorry about that. Okay, perfect. Perfection. So let's get back to this one. This is the video that we started watching. This is Becky Hill openly admitting that she was accused of plagiarizing the book about the murders, the Alec Murdaugh murders. And we started watching this video, and then the case came back on. So let's finish this video.
Behind the Doors of Justice, the Murdaugh murders, in which she details her role in the trial and her decades-long personal relationship with the Murdaugh family. But she's now accused of plagiarizing a section of that book.
I was shocked. I was disappointed. I was sad.
Neil Gordon is the book's co-author. He says he discovered what he called the ethical gaffe while reviewing thousands of Hill's emails that had been released to reporters through Freedom of Information Act requests.
She said that she felt like she was under a lot of deadline pressure, and she remembered that that particular article was on her email.
Okay, can we just get one thing, agree on one thing here? Is it just me, or does Becky Hill have an excuse for everything? It sure seems like Becky Hill legitimately has an excuse for literally everything. It's insanity. The woman cannot take responsibility for one bloody thing.
This screenshot shows in February, Hill received a lengthy excerpt of an article by a BBC journalist about the trial. It appears Hill copied from it directly for the opening of the book, prompting Gordon to publicly apologize to the BBC and the reporter.
I decided to look at our book because the words were very familiar to me. And sure enough, it was the preface of our book. I was sick to my stomach.
Hill has spoken openly about the Murdaugh trial on numerous occasions, including giving an interview in a Netflix documentary series about the case.
I had a feeling from our time together with the jury out at Moselle that it was not going to take our jury long to make the decision in this case.
In a statement responding to these new allegations, Hill's attorneys say she's deeply remorseful for this unfortunate...
Wait.
Going to take our jury from our time...
Netflix documentary series about the case.
I had a feeling from our time together with the jury out at Moselle that it was not going to take our jury long to make the decision in this case.
In a statement responding to these new allegations, Hill's attorneys say she's deeply remorseful for this unfortunate lapse in judgment, and this comes just months after Alec Murdaugh's attorneys had accused Hill of jury tampering, saying she pressured jurors to reach a quick verdict in hopes of securing a book deal for herself, a claim she denied and prosecutors called unfounded and not credible.
Because of the seriousness of these charges, when the judge holds the evidentiary hearing to consider whether to grant a new trial, Becky Hill probably won't be able to testify. If she does, she's going to risk being cross-examined, and her credibility is completely shot because now she's an admitted liar.
And Becky Hill's attorneys say she has reached out to that BBC journalist to personally apologize. This book had been self-published. It was only available through Amazon and Audible, but both authors now say it has since been unpublished. Guys.
All right, Trevor, thank you. And Eva, we know you've been covering this Murdaugh case for a very long time, since the beginning. What impact could this have now?
Well, you heard Trevor mention the defense attorneys had asked for a new trial, and they specifically pointed to the behavior of this clerk and this book. The court has yet to decide, so we'll have to wait and see if they factor this in.
Seems like every week, every month, there's something new about this case.
It keeps going.
Just keeps going. All right, Eva, thank you for that.
Well,
Okay.
hey,
All right. That's enough of that. Wow. We're going to come back from break and we're going to watch how this continues to unfold, ladies and gents. This is getting very spicy. I feel like the next witness, if permitted to testify, because Poot has already alluded to this in his cross-examination, he asked if there was like the bailiff Bill something or other, and then there was another person that he named, and he knew the answer. He already knew the answer. The answer was, yes, you did talk to them, and yes, you did mention this, and blah, blah, blah. And now they're going to take the stand and contradict what Becky Hill said. That's what I anticipate. Because again, for purposes of impeachment, the judge seems to be like she's going to allow this person to testify. There is a possibility that when they come back from break, the judge is going to be like, no, I am denying your request after further consideration. Is there anything else? Blah, blah, blah. And then they're just going to close it out for the day. And there may not be a hearing tomorrow. There may not be a hearing the following day. Today may be the end of it. But if she allows the impeachment evidence to come in, I'm going to be very happy. I'm going to be very happy to hear what they have to say, because I think it's going to be imperative for the case. I mean, honestly, at the end of the day, it's the state is just as much on the hook here as the defense, because does the state want a reputation for getting a false verdict? Remember how they celebrated at the end of the case? I mean, that was like the most disgusting display of hubris that I have ever seen from a state. Like, defense attorneys do that, but we're allowed to because we work hard and we are not working for the state. When you work for the state, for the government, for the people, allegedly, and then you come out and you boast about oh, what a great job we did, and you don't even mention the victims. I mean, that's just not right. I remember. Do you remember that display when they all came out and they were lined up from the Attorney General to Creighton to his team? Like they were just like, in the Murdaughs, not the Murdaughs. Well, yeah, I guess the Murdaughs. Who else would have been there? I mean, the Murdaughs were not there. Obviously, they were not happy with it, but they were lining up like it was getting dark. I remember this. I think I just got home from the trial. It was just, nobody was expecting a 3-hour verdict. Nobody was expecting a 3-hour verdict. And so the fact that Becky Hill had a premonition, a gut feeling, I believe she called it. She just has so much experience in this arena that she thought it was going to be a quick verdict. So you better get here now, because if not, you're going to miss it, you know? I'm wondering if she like talked to some of the jurors and they were like, oh yeah, this is not going to take us long at all. So she was privy to information that nobody else knew, which means she probably talked to the jurors. I think it goes without saying at this point, it's been said time and time again, that she communicated with the jurors, and today she lied about it today. Like she said, I did not talk to the jurors. And she actually, do you remember the Freudian slip that she had? She was like, I spoke to Bill, the sheriff foreman. The sheriff. Do you remember that moment? I mean, that was literally it. That was literally it, because the allegation was that the foreperson and her had conversations in a back room, 5 to 10 minutes, blah, blah, blah. And she accidentally slipped up and said, the bailiff foreman, or whatever she said, bailiff foreman. What is a bailiff foreman? That was a Freudian slip in my book. That's how I'm calling it. So they did. They acted like big superstars. If it goes back to trial, do I think there's going to be a different outcome? If the same evidence comes in and the jury renders a verdict based on the evidence, I think it should be a not guilty. I do. I still hold my ground. Now, obviously, when the new trial happens, anything can happen. There's going to be a lot of contradiction. There's going to be a lot of testimony that is not going to be aligned because memories are faulty. And especially when you lie, it's kind of hard to remember your lies. So if any of SLED lied, cough, cough, on the stand, I mean, all Poot and his buddy, his co-counsel, all they have to do is dig up the testimony. I mean, it's going to take a while, but they have to dig up the testimony of every single witness and read it before they testify. And if they see a single contradiction, then absolutely call them out on it, and it's going to be impeachment, and now their testimony is no longer believable. Do you remember you testifying in this case? On a different case? On this case previously? Yes, I do. And did you say XYZ then? Yes. And now you're contradicting yourself? Thank you very much for your testimony. That's it. It's going to be a lot of drama. I agree.
Please be seated. All right, Mr. Harpootlian, I believe it's you to present your witness.
Yes, ma'am.
Please be,
Rhonda McElveen.
Make sure that on your screen you press on the live button so that you guys can see this footage live. Because some of you are saying like it's live, get it back on.
Yes, that is.
I am caught up. I'm literally second by second watching this as it's unfolding. So if you are behind, all you have to do is click that live button on the bottom and it will take you to the live portion. So if you're a little bit behind, You can just press that button and it'll take you
Do
to
swear or affirm
where
that
we
the
are
testimony
currently.
you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, that's what I'm here for.
Thank you. Please have a seat on the witness stand. State your full name for the record, and please spell your first and last name.
Rhonda McElveen, RHONDA MCELVEEN. I'm gonna make sure I'm gonna stay here.
I'll try to make it clear. Is that better?
Yes, sir.
Say your name for the record, please, so I can make sure I can hear you.
Rhonda McElveen.
Your Honor, can you hear? Okay.
I can't hear you great, Dick. I can hear you, but I would doubt that anybody posted lawyers would hear you.
Is that better? No?
Is that thing on, Mr. Bailey?
I think it's somebody for the other courtroom. Somebody for the next door.
I don't want to get into the thing going.
Well, I can speak up.
haywire again.
I'll just speak up. How about that? I have a big voice. I'll use it.
It's just not on at all, though.
No, it's all right.
Is it on?
Yes, ma'am.
Okay. All right, Mr. Harpootlian, you may proceed.
I'll speak a little louder if that helps. Say your name again for the record, please.
Rhonda McElveen,
And Ms. McElveen, what do you do for a living?
Clerk of Court and ROD for Barnwell County.
Clerk of court in what?
Register of Deeds, I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the clerk of court of Barnwell County?
This is my 16th year.
16 years.
Wow.
And
I'm running again, sir.
you're up this
Shameless
year?
plug-in.
24 is
Yes, sir.
all right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Register of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group,
President of that group.
president of that group.
Yes, sir.
Now, are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there. There's actually 2 separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook that, or not handbook, but in the program within the CMS system, they actually have rules and stuff there you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
I mean, we understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct?
That is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking juries, do you assist as clerk of court? When I say assist, who actually picks the jurors out of a hat, or whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS system, and then summons are sent out. And then once we come to court, we usually do a roll call. We see what everybody's doing, what their jobs and everything, to help the attorneys to decide which jurors they would like to get. They have so many strikes, etc. And then you call the names, and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, like, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is a little, like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay. And the jury, they're sworn by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, et cetera, or if they request to see someone, then we manage to, I'll go in the door open. I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on. And then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case, by the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the most only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury room?
They sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye or they'll catch the judge's eye, and we'll get something handled.
Okay. So did you have any contact with the clerk of court of Colleton County prior to her being elected the clerk of court of Colleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks. Is that correct?
Yes, sir.
How did you come to be there?
When Becky and I met each other at a conference, clerk of court's conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case, two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Colleton County.
Okay. To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was her first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all, I mean, initially, what were you talking about in terms of logistics and how you did it and all those sorts of things?
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She wanted to write a book. Yes,
wanted
sir.
to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during
a guilty verdict will sell more books? Are you kidding me?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner.
Oh my
that kind of
God.
stuff, but that's about it.
That she needed a guilty verdict to sell more books?
That would be the best way to sell books, yes, sir.
the best way to sell books. Now, during this
Oh my
process,
God,
did
what
she
a
ever express to
selfish
you an
bitch.
opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty. And she made a comment that guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County and I was told that she had taken a juror home the night before. And I was in the courtroom and I saw her, and it was between the
She took a
pews
juror
and where the
home?
back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me. I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had to understand that you did not spend time alone with the jurors.
Okay. Now, I'm going to read you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent and what you should pay attention to? Did you ever hear her, what, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever heard her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3B extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony. So we would object any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled.
Yeah, I'll overrule it
Thank
too.
you.
Absolutely.
Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me.
Okay.
And sometimes there might be a staff member in her office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions. Look at his movements. Did you ever hear her say that?
Yes, sir.
Okay.
Now, this is actually shooting Poot's case in the foot.
Did you ever have
He's
any
destroying his own
conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the clerk's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir. I don't think so.
Okay. Now, let me deal with one last area.
Hey, Jane.
Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I've got a little frog in my throat. I'm fine, thank you.
I think I'll share my bottle over here if he wants part of it.
What's the clerk always the clerk? So, and I was there. You were there.
Exactly.
This
Kyle.
judge was not there.
Oh,
and
no.
Prosecution tables over here, defense tables over here, judges up here. And then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area. Is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir. For the
Now,
most part, now sometimes I was out there with the screen
right,
in the gallery.
right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda Ryder, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came in Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting, I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
Yes, sir.
And she was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
So she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had sealed, correct?
well, no, the only thing she could see was what was being put up at the time.
Right. But
Okay.
as they were put up, she could see them.
Right, but they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of those,
Right.
okay?
But she could see them.
Right, and Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either, okay?
And she turns out to be a writer, correct?
Yes, sir, after I found out, yes, sir,
And her name is Rhonda Rich.
correct.
She was given access to areas that only court personnel should have had access to.
Right, but then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, I'm a Sunday school teacher. Well, I immediately covered up everything I had.
You don't trust Sunday school teachers?
So,
You don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
I like this baby so much.
You determined she was not a Sunday school teacher, and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working. And that's when she put Miss Rich out in the gallery in control of that screen.
And she ended up writing the foreword to Becky's book. Is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had. Is that correct?
That is true. But now I'll be honest with you, sir. There's been a couple times when we had other people that were sitting on that side where we weren't planning on seeing sealed documents that day.
Right.
But there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, court's indulgence.
Oh, wow.
Mr. Waters, on cross-examination. Thank you, Your Honor. Just like that. 1 second. Oh, okay.
Judge, do you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth's got one. Thank you.
Great.
Ms. McLean, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. It didn't work.
Yes, sir.
Okay.
Wanted to ask a couple things. I won't be that long. And one of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, we ought to write a book or something.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh,
or anything
no,
like
sir.
that?
I'm crazy enough not to write one.
Okay. During the course of though, after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts
Uh-huh.
of the manual.
Okay, so she did send you those to take a look at and to review and that sort of thing. Is
Correct.
that correct? Okay. All right. And you were asked and again, Your Honor, just to be clear, I've made some objections.
You do not waive any objections by cross-examination. They are all preserved. You may proceed.
Thank you. You mentioned, some statements that you attributed to Ms. Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watches mannerisms, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with clerk staff and people like that?
Yes, sir. In the clerk's office. It might have been downstairs in the bathroom.
Okay.
Some of us had privilege to go to.
All right. So you and Miss Becky and other court staff maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
Now, when we were having those discussions, there weren't more than one or two, maybe three people there.
Okay. But just a few people there just talking back behind the scenes. That's what I'm
Correct.
driving at.
Yes, sir.
It was behind the scenes. And it's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in, in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay. And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other and actually having those conversations in front of the jurors, right? There's a big difference between
That's
those
where
two,
the Pooch
right?
shot himself in the foot
Okay.
right there.
And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair?
That
to
is
say?
true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens. Private conversations with court staff behind closed doors.
See how he's hammering it over and over again?
Saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right. Now, you were asked a little bit about Rhonda Rich, who was a member of the media, and how she was placed kind of back where the defense IT guy was. Is that correct?
I didn't say she was part of the media, sir.
Okay. Well, she was a writer.
Yes, sir.
Okay. All right. And then you said that eventually, though, Judge Newman stepped in, and then she was moved out into the gallery in charge of the screen out there.
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay. All right. And over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right. And inevitably, there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right. You never had a conversation with court TV or anything like that?
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. All right. And you're not aware of any image or confidential information or sealed image or anything like that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
No, I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said, that's improper. That I need to go report to the judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now.
Okay, so she wasn't privy to that information. That's fine.
In looking at back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. I had one for medical procedure done. I missed 2 days, but basically other than that, I was there every day.
All right. And there was a period of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
Court's indulgent. 1 moment.
I mean, it's cross-examination, so he's allowed to lead. He's allowed to go outside the lines a little bit. He's allowed to do that. On cross, you can do that. She's just a parrot. She's just yes, yes, no, 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 yes, yes, no, yes, no.
Nothing further.
Very good. Mr. Harput, then? Yes, sir.
Half a question.
All right.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We agree on that. Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time.
Yes, bring it back.
Her with that. Is that correct?
Bring it back home.
Yes, sir.
Good
And
job.
did she indicate to you what she talked to that juror about while they're alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
Improper?
I did tell her that I would caution her on doing that because the perception of dealing with
Impropriety.
jurors one-on-one is
Yes.
not tolerated.
Yes. Yes.
It's not
100%. Yes.
Thank you.
Thank you.
Thank you, Ms. McElveen. You may be excused.
Beautiful. That was a beautiful recross.
All right, Mr.
Gorgeous.
Harput,
Or
call your
redirect.
next witness.
Gorgeous.
Your Honor, we would call juror 741.
I know you're not going to. Well, that's right. She's an alternate. That's all right.
Is this Egg Lady? Are they calling Egg Lady?
We're not going to sign her a letter. We're going to go with 741.
I got you.
And Your Honor, while she's coming, my understanding is I'm limited to 4 questions.
Yes, sir.
He's limited
I
to
have
4
a copy, and I have given
Make it count, Poot.
the
Make it count.
court reporter a
Make
copy
Mama
of this
proud.
affidavit with the name obscured and the number, I think, as well. So, but the affidavit that supports this testimony that you're about to offer is Court's Exhibit 5.
Make DY Mama proud. Make DY Daddy proud. Come on.
For the jury and how long she was on the jury and
That's
if she
fine.
got excused. That's all we intend on asking these 4 questions.
All right, sir.
Unless Mr. Waters asks.
Sure. I mean, they'll have cross-examination.
I'll be crossing, so.
He would definitely open the door.
All right.
He's limited to 4 questions initially. Is that?
Yeah.
No, sir. He's just telling me that's what he intends to do. Fine. Sometimes you can hold lawyers to that, and sometimes you can't, Mr. Miller.
Yes, ma'am. Thank you.
I intend on only asking her those 4 questions.
That's fine.
Make DY Mama proud.
Yeah.
I'm excited.
Yeah.
If this is Egg Lady, oh my God, if this is Egg Lady. This is better than Baby Lady from the Johnny Depp trial. I swear to God. I think that's her. I think that's her. I think that's her.
I'll talk with the lawyer. Just do that.
I mean, I remember her. Was she Egg Lady? Bloody hell, I cannot remember. That's not Egg Lady. It's not Egg Lady. It's not Egg Lady. You're right. You're right. You're right.
The truth, the whole truth, and nothing but the truth.
You're
so
right.
help
You're
you
right.
God.
Sorry, I'm jumping the gun here.
You stand?
She's the alternate. She was the alternate.
Your Honor, I assume the same
She was the alternate.
apply to her that applied to the other jurors in terms of her image appearing.
That's correct. There'll be no photograph made of this particular witness who was an alternate juror in the matter. Thank you. You're welcome.
I'm going to refer to you as juror 741. It's what we got to do here, so we don't use your name, so people don't know who you are. Is that okay with you?
That's fine.
And you and I have met before.
Correct.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct.
And then you were interviewed by SLED.
Correct.
And you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
Correct.
I thought the same
Now,
thing, Greg.
Just
It's blanket
for
lady.
purposes of the record.
That's right. It's
you were
blanket
a
lady.
juror. You were selected to be a juror on the State versus Alec Murdaugh murder charge, correct?
Correct.
And you sat in the courtroom for 6 weeks and listened to all the testimony.
Correct.
And you were the alternate.
Correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay?
Okay.
Which you signed this morning, which was based on our initial interview with you and your interview with SLED. This is basically the same thing you told SLED. Is that correct?
Correct.
In your affidavit, you say before the defense put up their case,
Object to leading.
Sir?
Leading.
Overruled. Go ahead.
Yeah, he's setting the stage. Shut up. Sit down, cretin.
in your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, "The defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off," unquote. Is this true? Did Ms. Hill
Accurate.
say
That's
that?
exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two
We was
jury.
in two separate rooms, and when she came in, we all went in one room.
Okay. Paragraph number 5, Ms. Hill said, "If you get emotional, we want to see your face because that is what they want to see." What does that mean?
She said, "Don't get nervous. Don't be afraid to show your emotions because that's what they want to see."
Who wants to see?
I don't know who she was speaking of. I'm assuming the court.
Okay.
Don't be afraid to get
And then
emotional.
number
That's what you
6,
want to see.
Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall exactly what she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
Is what you put in this affidavit truthful?
Yes, sir.
And this is what you told us back in
I don't remember that
August,
months
I
ago.
believe. I think I interrupted you cooking Sunday dinner.
Right.
All right, thank you.
Gorgeous.
Please answer any questions defense may have for you.
Absolutely gorgeous.
Mr. Waters.
You call them defense.
All right, Mr. Meadows.
Yeah, because they are the defendant here. That's amazing.
Good afternoon, Ms.
Good
741.
afternoon.
It's nice to see you again. When's the first time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney?
I can't tell you exactly. It's been months. Probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or was there somebody else that talked to you prior to them? Any other attorney?
No, I think he was the first person I talked to.
You sure?
I think. It was so many people trying to call me, and I was trying not to be involved, so I can't.
Trying not to be
quite
involved.
remember.
That's really
But
nice.
he's the first person I seen.
The fact that she's coming forward
First
means a
person in
lot.
person?
Yes.
Okay. So when he came to your house?
Yes.
Mr. Harpootlian came to your house?
Yes.
And at that point, was Miss Holly with him? Holly, do you mind raising your hand? You see Miss Holly?
Yes.
Okay. And was anybody else with him?
Yes. He was.
Mr. Griffin? Thank
Mr.
you.
Griffin.
Thank you. And you gave them a statement then, right?
Right.
And did they record you? I mean, were they audio or video recording you? Did they say we'd like to record this?
No.
They didn't?
But neither did the people that came out. They didn't. I didn't know I was being recorded by them neither.
I'm not trying to fuss.
Oh, okay.
But is there an audio recording of your conversation with them that you know of?
No.
Did they say?
None that I know of. No.
Okay. So you don't remember saying?
No audio recording. We're required to tell her of recording her under rules. We didn't record her.
He's on cross-examination.
That's a good objection. I like it. I still like it. Good job.
And at that point,
At least you're showing us
and
your
that was
way.
again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly?
Roughly. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing?
Exact same thing that I told them.
Nothing less, nothing more.
Yes.
So Mr. Harpootlian, and you didn't sign an affidavit back in September or when you talked to him the first time?
No.
And why not?
Because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so.
When you say nothing officially, I don't know what you mean.
He was just coming out to ask, he was just asking questions about what went on during the trial. It wasn't.
But did they ask you to sign an affidavit that day?
No.
Okay. Did they ask you to sign an affidavit any time right after that?
No.
They never asked you to sign an affidavit until this week?
No, I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's it. I didn't say that. That's what the clerk of court said.
Yeah, I'm saying that's what you said to them. I'm sorry. Okay. And where did that take place?
She would always stand like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So you were there were two rooms, right?
Yeah.
Okay. One room and then the other room separated, correct?
Right.
And you couldn't hear people talk in the other room, could you?
No, that's why when she came, everybody came in one room.
Okay. So this comment you said she made, did she bring everybody out in the hallway?
Some people was in the hall. That's why I said she was standing right at the head of the door.
Standing at the head of the door.
Right.
Was Mr. Bill there? Your bailiff?
Yeah, he would be standing in the hallway.
He's all out there, right?
Right.
And then she said in front of everybody, the defense is about to do their side. They're going to say things that will confuse you. Don't let them confuse you or convince you or throw you off. She said that to everybody.
She said that to everybody.
So everybody could have heard.
Everybody could hear it.
Uh-huh. So they're going to use the why did 10 jurors line?
You said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was
jurors are
standing in
scared.
front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came, they'll let us know like after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from the two rooms into one room?
Some would be standing out. She was standing in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we'll be in the room and someone will be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I mean, I guess she didn't want to walk back and forth to room.
No, in fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you didn't. The statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said.
After,
When was that?
That was, I think he came in that afternoon, like at 2:33. So that was before he testified, I think.
And where was it?
Oh, in the jury room, where we were all, like I said, we were all meet.
And I guess what I'm saying is you're in two different rooms for a while, right? And y'all get up there, you split, don't you?
Yeah.
The people that talk loud in one room and the others in the other one? Pretty much.
No, it's not like that. It was just, they just split it off. They just asked us what room we wanted to go to.
So when you were fixing to come back to the jury room, to the box,
Mm-hmm.
you tell us you'd all go into one jury room together?
Only when she came to speak to us.
And Mr. Harpootlian asked you about, I believe, number 7 on the affidavit. And when did you sign this affidavit?
This morning.
And when's the last time you had talked to Mr. Harpootlian?
No, I haven't talked to him since he came to my house.
Or any of them before today?
No, I haven't talked to him since he came to my house.
Talked to anybody else involved in this case before today, since then?
No, he was talking to my lawyer.
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer.
Since when?
Since 2021.
Okay. When Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to?
All right. They apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
Yeah. I wasn't going to content. I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Well, say you're a lawyer for this.
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, ma'am.
I didn't have he was always my lawyer.
You didn't hire him for this?
No, I didn't hire him for this.
But he had talked to Mr. Harpootlian about your affidavit and your testimony today, hadn't he? Is that a yes?
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
When was he looking over the paperwork?
Oh, I guess ever since September, October. I wasn't really keeping up with it, to be honest, because I'm.
So do you know if he's talked to Mr. Harpootlian this week?
Yeah, he talked to him today.
Talked to him today?
We was together.
Who was together?
Me and my lawyer.
And Mr. Harpootlian?
Yes, when I went to go sign the affidavit.
Okay. Where did you sign it?
At his office.
At whose office?
Mr. Harpootlian office.
Your Honor.
I was supposed to.
I would object.
Okay.
This meandering, I mean, there's no jury here. It's you. And I don't know what this is.
How about helping a little bit? I think we got all the information. Yeah, all right. I think he's going to move on. Yeah.
And that's the last question Mr. Harpootlian asked you about this affidavit, isn't it?
What was the last question?
During the visit to Moselle jury, say the number, whatever the letter is, it doesn't matter. You saw a juror, and I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's
Correct.
the last question he asked you, right?
Correct.
So, and you have no idea what that conversation was about? Do you?
No, I don't.
Now, the next, number 8, he didn't ask you about was I also overheard discussions in the jury room that Mr. Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now, he didn't ask you that a minute ago, did he?
No, but okay, no.
And you didn't include that in the first conversation you had with them back in August and September in this affidavit. Miss Holly did you? You didn't tell them about that.
I can't remember.
Have you seen the affidavit Ms. Holly did for you back in September 1st,
Yes, Your Honor,
2022?
Ms. Holly did not do an affidavit. Ms. Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Ms. Holly thought was relevant at the time, but she can't be cross-examined.
That's not in evidence, Mr. Meadows, so I think we need
We'd
to
offer
move.
it, Your Honor.
Sir?
I'd offer it. Just to.
Well, how is this thing gonna be authenticated?
You know, even more importantly, he said, he can't question her. I'm sorry.
Several people can't talk at one time. I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
This is one Holly did when he first talked to her back in August, and she's referred back as
Miss Miller. Okay, Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said.
Yes.
I'm not going to allow this, Mr. Miller. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not going to allow that.
Thank you.
Good call.
You did not tell them about hearing that Ms. Hill had driven a juror home back when you met with them in September, did you?
I can't remember.
I'm sorry.
He's trying to impeach her. He's trying to show that she's biased and that basically she's been paid to be there today, in a sense. That's how I see it. I don't know. Do you all think that he's successful so far? I'm not really. I don't see it. He's trying. He's trying real hard.
On the
But I think
trial?
he's failing.
I don't know her. But that was the nickname they gave her. I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the case, just like everybody else.
Anything else?
Nothing.
Ma'am?
No.
So again, Mr. Harputler didn't ask you, but when you, in the affidavit of today,
Mhm.
I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Harputler today?
I don't know if I added it. We talked about it today, but I don't know if I mentioned it in September or not. But I know it.
You've ever talked about it, wasn't it?
Your Honor.
No, it's not.
No reason to raise objection.
The first thing is, Mr. Meadows, I'm going to caution you one more time about this. You
Yes.
cannot talk over a witness. The second thing is, you don't need to be marching all back around here. You talking only to me, not the jury or anything else. So let's slow down, and this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take tone. I apologize. She knows that, and I'm sorry.
Well, you're just talking to me. This is not some drama thing for the jury.
I know. I'm sorry.
All right. Well, let's finish this thing up.
The only reason I did it, what he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please
She's
don't do
admonishing
that.
the prosecutor.
Strike that from the record, please.
Don't strike. I'm
Let's
so
line
sorry.
Let's line this up.
Hey.
All right.
Smack.
Uh,
That was a smackdown. I'm starting to like this.
In
joke.
number 9 in the affidavit, that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate.
No. When we first left out the courtroom, we all went in the same jury room. And then they separated me.
And Ms. Simply, when I didn't mean to raise my voice.
Oh, that's
You know,
okay.
I apologize.
That's fine.
But when they started deliberating, were you in a separate room?
Yeah, when they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh? at
No,
all,
sir.
did you?
No, sir.
You didn't get to come back with the verdict, did you?
No, sir.
Have you read Ms. Hill's book?
No.
Okay. And I noticed your interview. I did watch it. And I think Mr. Radford back there, you can raise your hand, kind of Radford, I think came to your place and interviewed you.
Right.
At some point during the trial, I think there was some discussion that somebody might have wanted to do an interview with you.
Yeah, that's what she said.
Okay. And then after the trial, I think there was some discussion. Somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling an officer that?
Yeah, that's not what she said. She came to me roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said, she didn't say a few. She said, I have a lot of people that's inquiring to interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room, and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for an interview because no one wants to speak with you. That's what was said.
And did, I mean, you weren't happy with that, were you?
Yes, I was.
You were happy with
I don't need to be interviewed.
Dave Corsido. Should get a lot to your delight,
Briefly, Your Honor. Mr. Meadows just asked you a series of questions that I'm not sure I've heard before. Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Oh.
Miss Hill?
Oh. Yes.
Just you or all the
Thank
jurors?
you.
They had,
During the
they had a
trial.
bomb threat. And I think that was the day. And she approached me.
You?
Me, by myself.
By yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
Boom.
To you?
Yeah.
Not the whole jury, to you.
Becky Hill
Was
communicated
there
with the
anybody
juror.
with you at that time?
No. It was
Did
just
she indicate why they
Directly.
wanted to speak with you? Just you?
No.
During the bomb threat.
Did she indicate what reporters?
No.
And did she ever talk to you about doing interviews with the media after that?
No.
But you indicated she brought some cards at some point?
She brought cards in and handed to the jurors.
Before?
After the verdict was read.
Cards of media people?
Yes, sir.
Did she tell you she was writing a book?
No.
Did she indicate to you why it might be good for her if you did media interviews?
No.
But she had a conversation with you in the lunchroom of the
I
middle
believe
school.
it was the lunchroom. I think the day of the bomb threat.
The day
But
of the bomb
I'm
threat.
100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just
No.
her?
It was just her.
Pulled you over and said, "Hey, I can make you famous. I can put you on TV."
She said she had media that wanted to talk to me. That's what she said.
Okay. I hyperbolize. I apologize, Your Honor.
Yes, sir.
That's all I have.
All right, no further questions, Mr. Harpoon?
No, Your Honor.
Very good. All right, thank you very much, ma'am. You are excused.
Oh my God, I am melting in my chair. She just said Becky Hill approached her in the middle of trial, solo, without the bailiff, and communicated with her. Doesn't matter. Doesn't matter what they talked about.
That
They
it?
talked. The judge
One matter on the record, Your Honor.
The judge made
and
up.
That is it.
All right.
I think the judge made up her mind. I think the judge made up her mind.
Your Honor, earlier today, you received a very short affidavit from juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We either, but would you allow us to do that?
Well, I will allow, before I close the record with Ms. Harris, if you can get it to us.
Don't forget to like this video, comment below,
When can you
subscribe
get
to
it
the
to us?
channel. I love you all.
We can email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me, to Ms. Diaz, and to Ms. Harris, the court reporter. And I will say now that it's offered as a proffer, and I will receive it as a proffer. I have not admitted it into evidence.
Yes, ma'am.
All right.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that part of the record.
All right, but hand it up to me and let me see it. And also, of course, to Mr. Waters. I got two of these, Mr. Harputman. I'll give you one back.
By the way, the results of the poll were 75% saying he's going to get a new trial, Alec Murdaugh, because of all this. 25% of you said he won't. And Twitter is literally copy and paste. This is what Twitter said. Real quick. 75.3% yes, 24.7% no. So literally 3 out of 4 of you on both sides are saying
the hearing before Judge Newman
he's going to get a new
sealed the
trial.
body cam videos
Hey,
on
Nick.
May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going
and
on.
this is being offered as a after the fact email to Rebecca Hill, and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All
Honor.
right, I'll admit it. Mr.
Man, I need a
Waters?
shower after this. I feel so dirty.
As to this specific exhibit, Your Honor?
Yeah.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to
Very
Your
good.
Honor.
All right.
Oh, there's the preacher.
Yeah.
All right,
There's the
hang
preacher
on.
from the trial, by the
You
way.
got a copy of it
He was
there.
at the trial preaching and having sermons with the members of the people outside. I call them Father Mackey, I think, from South Park.
The proffer is your exhibit 1, Mr. Harputman, and this, which I have admitted, is your exhibit 2.
Thank you, Your Honor.
All right. All right. Now we proceed to closing. You prepared?
Yes, ma'am.
Very good. Mr. Waters.
Thank you, Your Honor. Just to go back and reiterate as to the standard, and ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or
That's
what
Fitz
was
news.
inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because, there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the
Talk about the
various
facts,
South Carolina decisions,
buddy.
that's
Don't
unrealistic.
talk about the law.
And not surprising
Tie it into the
to
facts.
think that sometimes things like that can happen, an untoward comment or something
I don't think you have anything, bud.
was said. But that, that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law of the testimony at trial. Answer question number 2, yes. Absolutely, yes. But then goes on after that to say she heard some communications from the clerk, and then says, well, it had an effect on my verdict. Even after she had already answered question number 2, when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that, then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors. Not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what she says, that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling, because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, this juror is represented by Joe McCullough. And ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, for for a juror to have a second thought. But the law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation. And the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And Your Honor, I would say that the other 11 jurors are credible. They were strong. They were clear with Your Honor. And I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda. And we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda.
Am I the only one who just I can't see the
And Miss Rhonda came in and
how
testified.
he's tying it all together? He's just
But I would submit to Your
blah.
Honor that
It's
this
just words
is
coming
kind of
out.
a red herring, because what Miss Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team.
I
when
lost
we're not
him
in open
completely. I
court,
can't
where
find
we're
his
discussing
thread.
things, the kind of conversations that go on among court staff behind the doors. Those types of conversations go on, but that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. And I probably was as repetitive as anyone here today and asking that
As
question
anyone?
over and over
No,
again,
just
because
yourself,
I
buddy.
didn't want that point to be lost. That Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact, because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, yeah, maybe I did this, or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict. This was the product of honest deliberation. We would be the first ones here standing here to say that. But what we do know,
all it takes is one, Creighton,
is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced. Nobody tried to influence. And regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Okay. Defense?
Mr. Harpootlian.
Mr. Griffin will be arguing.
All right.
That's it.
Okay, if I stand here, Your Honor.
Go
That way I won't be interrupted by Mr. Harpootlian as I'm
Go get him,
trying to
Griffin.
make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance. That's what we're following here. And reading, excerpts from State v. Green, first, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different? It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury and Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption, that we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we proved prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember, and then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's 2 deliberating jurors down. The third deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alec Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. I mean, she crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her, and that pretty much came out there. I mean, so, you know, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard, and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It is really an impossible task, because you don't know what's influencing a jury, and frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty, and there was really no testimony about did that affect your verdict, but it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial, and we're granting a new trial. I mean, this is prejudice, and this has been proven. I mean,
I want to
Ms.
see
Hill
the
is not
judge's face when he says
Ms.
these
Hill is
things.
not credible. And she's talking about her book, talking about taking literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes and then I will come and make a ruling from the bench on this matter.
Ruling today?
Court will be at ease.
Wow. Ruling in 20 minutes. Oh my Lord. I love this judge more and more because she could have been like, you know what, I'm going to take this under submission. You all may file any briefs on the matter. I would love to entertain any additional arguments you all may have. She's like, no, baby, I had enough. I'm done. I don't want any more of this. I know I reserved 3 days for this. I'm going to shave off 2 of those days. Golly. Yo, this is big. This is huge. This is huge. We're going to get a ruling today, very bigly. I mean, look, I wish Poot or Griffin literally just put a PowerPoint slide of this right here. This right here is enough for a new trial. It's one of the things. Is this still your verdict? Question number 1. Is this still your verdict? This is for Juror Z. Is this still your verdict? Was that an accurate statement about the verdict at the time? There's a long pause, but yes, ma'am. She's afraid to say no. Although I'm sure she wanted to say no. She said she was pressured into it. I believe it was her. Maybe it was some other juror. I'm starting to get them all mixed up because there's so much going on today. Question 2. Was your verdict entirely based on the evidence presented during the trial? Yes. Did Ms. Hill make comments to you before the verdict? Yes, she did. Question 3. I'm sorry, that was question 3. Question 4. What did she say? Becky Hill said to watch his actions, meaning Alec Murdaugh, to watch him closely. Question 5. Was your verdict in any way influenced by the communication of the clerk of court, Becky Hill? Yes, it was. My verdict was influenced by the communication by the clerk of court, Becky Hill. Why? Question number 6. Because she made it sound, Becky Hill made it sound as if Alec Murdaugh, was already guilty. So I know there's some people in the chat. I've been watching you all. I know there's some people in the chat who are like, this man deserves everything coming his way. And you're absolutely right. I agree with you 100%. 100%. This man is guilty of fraud, self-admitted. He stole money from clients. He defrauded people. He stole money from the firm. He misappropriated funds. There's still like $6 million or so unaccounted for that he took, that he never returned, that his partners had to fill in the gap to give the money back to the clients that Alec Murdaugh stole. He's a thief, a scumbag, a liar, and a sack of shit. However, did he get a fair shake for the murder trial and the accusation of the murder allegations in Colleton County, South Carolina in February and March of 2023? Well, it's shaping up to be a no. He did not get a fair shake. He did not get a fair trial. Becky Hill, clerk of court of Colleton County, at this point, I think it's all but clear, has actively interfered. She injected herself. She put her hand into the jury and said and suggested, made suggestions, which she's not supposed to do. And is Alec Murdaugh, the scumbag that he is he entitled to a new trial? And the answer unequivocally is yes. If the judge says anything other than Alec Murdaugh is going to get a new trial in 15 minutes, I don't know what's going to happen to our judicial system. That's my opinion. And feel free to disagree. This is the beauty of life. This is not like a one size fits all. The whole point is to have an open discourse about the subject. And I welcome open discourse. I don't know if you all have been paying attention, but like there's lots of people disagreeing with me in the chat. And I love that. I love when people disagree with me because I have a chance to learn something new. Because if I'm going to be like, okay, who disagrees with me? Block, block, delete, block, block. Like, then I'm creating my own echo chamber. I don't want to create an echo chamber. I want open discourse. That's what I'm all about. Now, Twitter is a different beast. Like on Twitter, I will block those crazy Amber stands. That's a whole different ballgame because they're just heinous beasts who like to attack me for no reason at every turn, at every opportunity. That's a different story. But open discourse and disagreement, I always welcome. And I've learned the hard way because it wasn't always like this. In the beginning, I was very soft-skinned. I will say that. But I've learned my lesson. And like, honestly, please disagree with me if you disagree. Don't be afraid. Don't be afraid to be like, DUI guy, you suck. You're an idiot. You're an asshole. You're completely wrong about this. Alec Murdaugh should never get a new trial, and here's why, and present your argument. And I will listen, and I will render an opinion, or not an opinion. I will render a judgment based on your opinion. And maybe you are right. Maybe you have maybe I'm missing something. You know what I mean? So, I don't know. People in the chat right now are screaming new trial. Some people are saying Twitter is a cesspool. I don't disagree there. I can't believe excuse me. I can't believe I've been live for almost 6 hours. My voice is about to literally go. I'm still sick. I'm still getting over this cold. I'm so drugged up on like, what did I take? I took NyQuil. I took Sudafed. I'm still functioning. I'm still alive. But that's my opinion. So, no, you know, if you didn't know before. We're almost done. We're almost at the finish line, folks. We're almost there. We're almost there. Beth Meadows, thank you very much for becoming a new member of the channel. Welcome, welcome. By the way, don't forget to like this video, comment below, subscribe to the channel, join in as a member if you haven't already. So thank you for joining on as a member, Beth Meadows. Kathleen Nurse says, DUI guy, will you publish the judge's written judgment on your channel? There's going to be no written judgment. I'm going to publish the oral opinion that she is about to give in 12 minutes right here live on my channel. So we're going to watch it and then I'm going to comment on it. They are on break right now. Yes, they're on break until 5. The judge is making a decision as we speak. She's in the back room. Dana Loves Zumba says, thank you very much. She says, remember, there is only a 17-minute window from the killings to when he left, according to his phone and OnStar data. So now you're referring us back to the criminal trial in South Carolina, February, March of 2023, before the verdict was rendered. This was part of the evidence that came in. I think that's accurate. That rings a vague bell. So thank you for that. Dana Loves Zumba. I actually never tried Zumba. I should try it one day. And that's my opinion, good grandma. Does anybody? I want to hear the disagrees. Okay, so I've heard all of you that are like, I agree with you, DUI guy. I want to hear. I want to highlight, and I want to have, like, in the 10 minutes we have remaining, I really am curious. I want to have a discourse. Why do you think Alec Murdaugh is not entitled to a new trial based on the new evidence about the juror tampering that has just come to light? Go ahead. This is your moment to shine. And I'm going to give you time. No rush. I'm watching the chat very closely. Because I'm curious. I want to know, because there's got to be an argument. Everyone's got to be, someone's got to be devil's advocate. Don't be shy. Here we go. Okay, well that's even more. Greg Hansen goes a step further. He says, I don't think he's entitled to a new trial. It should be dismissed because the state completely effed it up. Mike Tyke says, I would love to argue that, DUI guy, but I can't think of one, honestly. Keep my silence because I'm for a new trial. Well, if this was the UCMJ, he would be tried by military judge tribunal and be found guilty. Very possible. I mean, we're not in a military court, but I'm still waiting for the arguments why he should not. Okay, here we go. For one, there is no evidence that will come. There's no evidence that will come for in what if he get the same verdict as I last trial. That is a very confusing statement, but I think you're trying to say that it's the same evidence, but it's going to be a different jury, not tainted, right? Hopefully. I have issues with the credibility of Becky Hill or the one juror who contradicted the other 11 jurors. So you have issues with both. That's interesting. So you're like, that's both. I love that. I love that so much. That's a really good, honest opinion. You have a problem with Becky Hill's credibility, but you also have a problem with the one juror who contradicted the other 11. That's fascinating. So you're like on both sides. You're your own devil's advocate on both sides. The new trial would be for the same charges. Yes, Tina. Why wasn't Egg Lady allowed to testify? Judge didn't let her. She said, I don't need her. Brenda says, I changed my vote. There's evidence of witness tampering. I'm now convinced. I'm still waiting for you. I'm still waiting for the devil's advocates to come out. Come on, you all. There's so many of you who are like, no, crucify his ass, boo-hoo, tears, salt, salt, salt. I saw those comments. Where are you guys now? I want to hear your arguments, please. Oh, Romeo, wherefore art thou, Romeo? Deny thy father and deny thy verdict, for I shall no longer be a juror number 3. DUI guy, Becky didn't specifically state her opinion. The person interpreted on their own impression how they felt Becky thought. In real life, that's called putting words in another's mouth. Wait, Scott Peterson. Was Scott Peterson the owl murder guy who said that the owl broke in and that's why his wife fell down the stairs and died? Was that Scott Peterson? No. Wait. Oh, pregnant wife and unborn baby. I forgot this one. Yeah, the Innocence Project appears to be helping him. Oh, I'm thinking of Michael Peterson, the staircase murder. Thank you for that, kind stranger. I knew it was a Peterson. Like, that's what jarred my memory. It was Michael Peterson. Yes, thank you. 4 minutes, T minus 4 minutes until verdict, essentially. Anyway, we got distracted. What were we talking about? So yeah, if you have an argument, still, I'm opening the door. Like, this is your time to shine, unless I missed it. Please don't. If I missed it, this was not intentional. It was just they were flooding in all these comments. Hello from Sweden. The judge, she blinked when she announced her verdict. That means to who? I don't know. I don't know, Rudolph. Rudolf Sturt Hammerstrom. If it is Sweden, I'm hoping I'm pronouncing the accent correctly. Rudolf Sturt Hammerstrom. And I know the Swedish, they like to emphasize their syllables like that. I hope I'm probably butchering the fuck out of it, and I apologize. I'm a racist bitch, apparently. I don't know. I love accents. It's not Yiddish. No, Ski Mask Boy. It's not Yiddish. Will Longcrown get in trouble for showing the alternate juror and she came in? I caught that too. I mean, like who's going to enforce that? Like, there's nobody to enforce that. I love how international we are. Shout out, where are you guys from? Shout out the state or the country. If you're in the US, just tell me the state. If you're in a different country, shout out your country in the chat right now. I want to see how many countries do we have represented right here, right now, 6 hours into this bloody hearing with 1,200 of you here watching. Let's see. I'm going to read it out loud. Let's go. Arizona. Oh my God, this is crazy. Arizona, Idaho, Connecticut, Virginia, Nebraska, South Carolina, Poland. Hey, Poland, Missouri, Maine, California, Canada, British Columbia, Canada, Great Britain, England, Atlanta, Florida, Scotland, Texas, Ohio, Colorado, Czech Republic in the house, Greenwood, South Carolina, Netherlands, Idaho, Kentucky, represent, yo, Indiana, Georgia, Canada, 4chan, Nevada, Alabama, Indiana, New Jersey, Michigan, Arizona, Pennsylvania, Missouri, Washington, Mississippi, South Texas, London, Canada, good grief, New York, Riyadh, KSA, what is that? Riyadh, South Africa? Somebody fill me in. Arkansas, Sweden, Florida, Maryland, UK, Pennsylvania, British Columbia, Germany, South Carolina, Arkansas, Scotland, Missouri, Utah, Russia, Texas, Portugal, Australia, Maine, UK. Oh my goodness. Iowa. Okay, you guys are from all over. This is insanity. I can't keep up. Wisconsin, Planet Earth, Maryland, East Texas, Kansas, Vermont. Okay. Oh, Saudi Arabia, Kingdom of Saudi Arabia. Thank you for. I did not know. I did not know. Thank you for filling me in. I feel like I should know that. I feel like a dumbass. Kingdom of Saudi Arabia. I've never heard it referred to as KSA, Kappa Sigma Alpha. If he gets a retrial, can Becky catch charges? Those two are not mutually exclusive. She can deny the retrial, and Becky can still catch charges. She can grant the retrial, and Becky still catches charges. She can deny the retrial, and Becky does not catch charges. She can grant the retrial, and Becky does not catch charges. It's literally 4 possible options. Excuse me, there are 4 possible options. Oh, wow. Pyongyang in the house. Finkel White Right. That's legit. Kakistan? I know there's a lot of, Uzbekistan and Turkmenistan. I've never heard of Kakistan. I feel like you're fucking with me. And if you're not, I deeply apologize that you have to live in a place that has Kaka in the name. I'm refreshing to see if I'm lagging or something, but no, court is still not back. Kat Buchanan, what's up? What's up? What's up? Long time. I missed you too. 20 months. Wow. That is a fake place. Of course it is. Kakistan is near Crimea. Okay, he wrote Kakistan. So maybe Kakistan is a little bit. Is it better? It's still, that's a sucky name. That is a place. Okay, well then I deeply apologize for every time you have to spell it. Anywho, Wakanda forever. May he rest in peace, by the way. What a man.
Order, all rise.
Here we go.
Please be seated.
New trial. Come on. Come on, Judge. Don't disappoint me now.
In the matter of the state of South Carolina against Richard Alexander Murdaugh.
Oh my God.
2022 GS 1500592, 593, 594, and 595.
Thank you, Alabama Rose.
The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer.
That's a good start.
And my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Becky Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, one, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. Two, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible. Oh! Ms. Hill was attracted by the siren call of celebrity.
Oh
She
my
wanted
God!
to write a book about the trial and expressed that as
Yes!
early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books.
Oh!
She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no.
Oh?
Each member of this jury took their involuntary
Wait.
assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton
I
County
was going to
stood
say
to
that
their
Becky
duty
influenced them, but
and
they did
rendered
not
their verdict
affect the
without
verdict.
fear or favor. It was a difficult task. 11 of the jurors very unconditionally
He's
said
not getting a new trial.
they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations, but the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task.
Oh my God.
I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this.
No new trial.
On the strength of some fleeting and foolish comments by a publicity influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial.
It was not enough
The
for her.
factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge, and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Thank you, Your Honor.
Thank you. Let me say this, and I should have said it before I began my order. Hey, members of the audience, would you just be patient with me for one more minute? Please keep your seats.
Oh,
I have probably had more experience with trial and appellate work than anyone else in this room for many years. And it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before.
Yeah.
I doubt whether our appellate judges have seen a case such as this before.
They're setting precedent.
And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the
Why is he still
record,
smiling?
I say, as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
Wow. Wow. I was not ready for that. I was not ready. I was ready for her to drop the hammer. When she said Becky Hill clearly did this for celebrity, what did she say? Celebrity purpose, because basically she wanted to, Becky Hill wanted to sell more copies of the book and she needed a guilty verdict. She did not find Becky Hill's testimony credible at all. But then she goes on to say, but all jurors still unanimously agree. They're fucking terrified, lady. That is the wrong call. I'm sorry. That is the wrong call. A new trial should have been granted. They should appeal. What scares me the most is that she said she read 6 weeks of testimony. She read the entire transcript. That's insanity. And I wonder if that somehow tainted her opinion of the case. I don't know if she should have done that. I think her issue should have been limited to the issues before her. I feel that her reading of the transcript cover to cover has tainted her opinion of this case. This is just my personal opinion. I could be wrong. I don't know. Because she's kind of like a hybrid trial judge / appellate judge, kind of. It's a very, like I said, it's a very, very weird position to be in. But why did she read the entire bloody transcript? That makes no sense to me. I think Poot and Griffin need to appeal this, and I hope the Court of Appeals grants a new trial. I think a new trial is still merited. I think the judge made the wrong call, even though she laid it out nice and thick. And Murdaugh is gonna rot in jail for the rest of his life, no matter what. So who cares at the end of the day? I'm not trying to set him free. I don't give a shit. I care about justice in South Carolina. And the judge basically all but admitted, like, yes, there was corruption. Yes, there was tainting, but it didn't affect the jury, as I heard them say, except for one juror who was ambivalent. I want to see charges on Becky too. And that's still forthcoming. And maybe things will change. Like while they appeal this, if criminal charges come forward for Becky, maybe that will sway the Court of Appeals in some capacity. I was certain. Even you guys were certain. 3 out of 4 of you. Welcome, Kathleen Nurse. Welcome to the channel. Thank you for joining as a member. Don't forget to like this video, comment below, subscribe to the channel, join in as a member. And And by the way, I tagged it, but again, Alabama Rose, thank you for the 10 gifted subs. I really appreciate it. That is so awesome of you. Thank you so much. What a crazy day. What a crazy, crazy day. Well, I can't believe it's been 6.5 hours. Doesn't feel like it, does it? At least not to me. I've been having so much fun. I missed you guys. It's been so long since we did this. The last time we were streaming this was actually, I think, the Murdaugh trial, like a year ago. So, yeah. It's good to be back, even though my voice, I'm probably going to wake up tomorrow like with no voice. Becky will now write a new book. Poot kind of alluded to this. All right, here's the press conference. Let's watch the press conference. There's still no sound, so this is not me as far as I can tell. Sound is turned on. Come on, Long Crime, get your shit together. I can't hear anything. Volume is turned up. Yep. Here we go.
We met our factual burden. 2, she made it very clear that the law in this area is unsettled at best.
Yes.
And that it means it's ripe for appeal.
Yes.
So the facts are settled. Becky Hill's not credible. The judge found, in fact, that the statements were made to the jurors. She just found that we couldn't show prejudice, but conceded that we may not have to show that if she's wrong about the law and the law's unsettled.
So Becky being not credible if she's wrong helps you at the next appellate level, or maybe the Supreme Court or the federal
Next level. Next, we go from here to the Court of Appeals, and then the Supreme Court, if necessary, our South Carolina Supreme Court, and then federal court.
I have to be honest with you, I didn't really believe the whole story with Becky Hill until today's testimony, and I have to tell you, it did sway me quite a bit, because I didn't believe it. Explain to us how you found out this information.
Go ahead, Jim.
Well, we're glad you're being honest today. I mean,
Haha, today.
no, I mean, and we found out the information by talking to the jurors. You heard the alternate testify today, and honestly, that was really the first one-on-one interview that we were able to get. We had gotten some indications from lawyers who represented some other jurors that we needed to go down this road, and when we finally met with her as she's cooking Sunday dinner in her home down a dirt road, I mean, she told us things that were jaw-dropping, and so that's how we found out.
And we rode down a lot of dirt roads. In Carlton County on Sunday afternoons, knocking on people's doors. And that, that's shoe leather is the way you work cases. I know, everyone's used to social media and electronics, but you got to knock on a door and you got to ask questions. And that's what we did. And that's how we proved to Judge Toll that Becky Hill attempted to influence this jury. She said for the siren call of
publicity and money to sell a book. I mean,
right.
We were, denigrated, made fun of, chastised because in our initial filing, we pointed out that she had a profit motive for doing what she did. And guess what? Justice Toll ruled that was exactly the case today. So we feel vindicated on the facts. The law is unsettled. And early on, she acknowledged, and we all acknowledged, this was not going to be the final say-so on the law. That's going to be determined by the appellate courts, and that's the next step. If we had lost today, I mean, we did lose today. If we'd won today, the state would be appealing. So no matter who.
True, very true.
Today,
Absolutely
it's
true.
just one step in the process. We would not have a trial next week or next month. It would all be wrapped up and gone up to the Court of Appeals and the Supreme Court, and so we're prepared for that.
But the good news is we agree The court agrees that Becky Hill attempted to influence these jurors, that she made these statements. With the facts resolved, the only issues, what is the law? And as Judge Toll said, that is unsettled. This is not, it's going to go through the appellate courts, and we feel strongly that we'll win.
Thank you all.
Wait, one more question.
How important is it to you all to get a different standard for the burden of proof when you appeal this? Do you think you can win under
A different standard?
that she said, or do you think you need burden of proof that you all want?
Well, we feel confident that the burden of proof is, that we get a presumption based on our factual findings here. And so if we win that legal standard, on this record, we get a new trial. If we lose that legal standard in our state courts, then we probably don't get a new trial. But we go to federal court where there is no dispute in the Fourth Circuit where we would end up for what the standard is, and it is a standard of presumption. So it's either going to be decided, in my view, in our favor in our appellate courts, or 4 or 5 years down the road in the federal courts, unless there's a change of federal law.
And would there be a different outcome if you get another trial?
Seriously?
Yes, there would be.
Yeah.
But I'm not going to tell you why.
Absolutely, yes.
It doesn't discourage you that Justice Toll at the end said she agreed with Judge Newman about the facts and the verdict and how it was, that it was a compelling case and all of that.
No.
Yeah, of course. Come on. Well, what silly questions are these reporters? Were they bored yesterday?
I disagree with Judge Newman. The facts were very thin. No, she's not.
Yeah, there's an innocent man here who's wrongly convicted.
And
we didn't expect her to say that. So.
But the appeals court could say it's harmless error, is my point.
They can't.
No.
They can't. This issue is not harmless error. Cannot be.
Thanks, James Forbes, for joining on as a member.
You said that you're investigating who might have actually committed these murders.
Yes.
Have you all found anything that you think you want to share with us?
We have developed some information. We want to get this behind us, and we'll be pursuing that in the near future.
About who committed the murder?
Who really did it?
Do you believe Alec Murdaugh has information? Because his voice is on the count video. Do you think he has information about who did it?
Well, if he did, we couldn't tell you. That's called attorney-client
I know,
privilege.
but do you think?
Thanks for being a
Can't
member,
think
Alice.
about what my client could have told me. That would be attorney-client privilege. These rules are so pesky.
These rules are so pesky.
You get credit.
How did Alec react?
Thank you.
Pardon me?
How did Alec react to that?
Fine.
Seriously, what stupid questions? They're just trying to get like drama.
Thank you, gentlemen. I think those turners were just swimming up here. You know what I mean? Swimming down, and when they got ready to drown, you grab out everything you can. That's what I think. They're just swimming up here.
Nicely done. You got the best.
I know, right?
Yeah, literally, Kathleen Nurse.
You gotta stay here. Pretty big case.
Buzzword fishing.
When you're drowning, you're gonna try to grab everything you can. Don't care what
Flimsy questions.
Try to hold on to it, not to-
Romper room reporters. You guys are so fucking on point today.
Good afternoon, everybody. On behalf of my 5 jurors that I represent, we're very pleased with the decision that Justice Toll rendered. This is what justice looks like. Sometimes it's
Excuse
messy,
me?
sometimes it's easy. This was not as easy as it looked. There was some very good lawyering on both sides, the defense and the prosecution, but the law is clear. And you heard from 11 jurors in no uncertain terms that their verdict was their own conscience. It was not influenced by anything that may have been said or done by anybody other than the testimony, the law, and the evidence. They followed what Judge Newman told them to follow. Yes, there was one
Okay,
juror.
15 minutes of fame, lawyer.
Don't question her veracity in whatsoever. I disagree with Mr. Harpootlian. Nobody on our team ever called that juror a liar. That is her conscience. And like the state said, we can't have verdicts that go in perpetuity and jurors can constantly say, well, this was my verdict then, but today it's different. You vote once in time. And
Hold on a second.
I
Did
think
he just
Justice
say
Toll
that he
believed
coached
that
his jurors
the
to
verdict was the
say
product of
to stay there, stand their
pre-negotiations?
ground?
Yes, inside a jury room, it's tense. You often hear that there's arguments one way or the other. but she did not feel that this verdict was the result of anything that Becky Hill had said or did or any other court officer. And so, this is the verdict that we have, what Judge Newman told them to follow. Yes, there was one juror. I don't question her veracity in whatsoever. I disagree with Mr. Harpootlian. Nobody on our team ever called that juror a liar. That is her conscience. And like the state said, we can't have verdicts that go in perpetuity and jurors can constantly say, well, this was my verdict then, but today it's different. You vote.
Okay, I take it back. I got a little heated. I
think Justice Toll believed that
I once was. I have a problem with some of the things that we've heard Becky say. I'm thankful that it didn't sway the jury. But we have to be.
Oh, I have a big problem with the things that Becky has said. And it's clear that there was some inconsistencies regarding whether she rode with a juror.
Dusty, you are dating yourself.
And I think Justice Toll let the public know and let Becky know exactly what she thought of some of her testimony.
That goes back
and I don't
ages.
think we've heard the end from Becky.
Does anybody know this?
She may
The
have
lawyer
to answer for some of the things. I think Justice Toll gave a foreshadowing of what may be coming to Becky.
Yeah, I think so too.
I wouldn't say impeached. I just think that she didn't believe a lot of it. But it's not her job. Becky Hill was not on trial. This is not Becky Hill's trial.
Not yet. Not yet.
No, her credibility was not the key question in this trial. The key question in this trial was what was the jurors' verdicts. That's it.
Correct, but her credibility regarding what she said or didn't say in front of them.
It's not, because the ultimate question was
whether they were in the
right, and she already discarded, I believe, what Becky said. I don't think she believed that Becky didn't say anything. I think she believed that Becky actually did say a lot. And I think that Becky, right, but that had nothing to do with her decision. The decision was, what did the jurors say? And that's what we were dealing with between the time the trial started and the time that they rendered their verdict. Not what may have happened.
Yes, they still can, James.
Since March 3rd. Since March 3rd, obviously, there's plagiarism allegations. There's allegations that, obviously your son was indicted. There's allegations.
This guy needs to sit the fuck down. I'm sorry.
And there's allegations.
He's not bringing anything to the table.
All that will take place in due course. And what we're going to ultimately see, what Dick Harpootlian said is,
he's boring.
Is our state Supreme Court going to say we stick with the Green decision, or do we go back to the United States Supreme Court decision in Reamer? And all a defendant has to show is that a court official makes these kind of substantive merit statements to a jury. And if they do, does it guarantee them a new trial? I don't think at this point we know that it's the Green decision, and you have to show that impact on the jury. Thank you.
Thank you very much. Justice been served.
All right, prosecution up next. Or is it done?
I can go to the house now.
Prosecution has to have their moment of glory, like pound the chest. Look at us, we won again. Bah! King Kong win one more time. Bah! Justice has been served. Boom! Pound chest.
Is Creighton coming? Are we done? We're done.
However, if he does come back, I'll run on back out here. He's not. This is one case where it's good to come last.
Creighton won. This is his moment to be in the spotlight. Where is he? Come on, Creighton. You don't want version 2.0 of your victory lap? Really? I'm actually disappointed in you, Cretan. I was expecting your chest pounding. Line him up, knock him down. No? Highly disappointed. Highly, highly disappointed.
Everybody else snuck off. Is that right? I think so. Pretty sure they're not.
Brother, y'all take care. Y'all drive careful home. I'll pray for you and your family. Everybody be safe.
Oh, there's the preacher. He wanted his camera time too. Shit, I don't blame him. He's great. He really is great. I'm gonna pray for you and your families. Sorry, the noise of the microphones is irritating me, as I'm sure it's irritating you. I'll give it another couple minutes. If not, we're just gonna wrap up.
I'd like to thank you all for getting my mic flag in the show.
But I think it looks to be done. I don't think Cretan's coming. I'll give it one more minute. Like 45 more seconds, and then we'll. Yeah, I don't think it's happening. All right, we can wrap that up. Post trial thoughts. Becky Hill is cooked. No question about it. How cooked is she? That's where the questions lie. We clearly have a ruling from the bench that Becky Hill is not a credible witness. Her testimony is not reliable. And there's a lot of holes, problems, and questions about her testimony that has been contradicted by unbiased witnesses, including several jurors and the clerk of court of, what was it, Bellwater? I'm sorry, I missed the name of the county where the other clerk was from. So clearly we have contradicting evidence, contradicting testimony coming in from a biased witness and an unbiased witness. And usually you are going to lend credibility to the unbiased witness, because Becky Hill is a very biased witness because it's her ass in the hot seat. So now the question becomes, is the investigation going to lend any criminal charges? And I don't know the answer. I mean, I hope so, but the amount of corruption going on in South Carolina, it literally is a coin flip as to whether or not she's going to face any criminal charges. Is she ever going to actually go to trial? Is she ever going to plea? Is she going to go to jail? I mean, I don't know. I really have no clue. I need more. I want to know more. I want to know what they find. I want to see if they can find this missing cell phone that was dumped in the dumpster. I want to see if they can find some evidence of her misconduct. I want to see if there's a paper trail in the court in the court where she was a clerk. There's a lot of questions. There's a lot of questions that we need answered before we actually get. But yeah, I think this sums it up very nicely, Jimmy. I mean, the judge is very eloquent. At the end of the day, despite her ruling that I disagree with, in the beginning I wasn't sure about her. Towards the end, I loved her. Even with her wrong ruling, I love the judge. And I know some of you disagree about Newman. My opinion about Newman, I highly disliked Newman. I disliked his demeanor. I disliked his ruling. I disliked his opinion. And that's just my opinion of the judge. Now you get to see DUI guy render an opinion about a judge that rendered a verdict that I disagree with. I still love her. Despite her wrong verdict, I still love Judge Jean Toll, or whatever her name is. I really, really like her. because she was fair. She literally like outlined everything very neatly, very cleanly. Even though I think it's the wrong decision, it's her decision. She's allowed to render a decision. That's her job. And so now they're going to appeal, and we'll see what the Court of Appeals will say. But to the bitter end, I mean, after I learned her a little bit, I really started liking Judge Toll today. Judge Jean Toll is 5 stars in my book. I can't say the same about Judge Newman. Sorry, not sorry. It's my personal opinion. Feel free to disagree, and I know a lot of you do. I will never change my mind until I see a different Newman, if I ever do. So at the end of the day, I hope Becky Hill faces criminal charges. I hope she really gets a stick up her ass so she learns her lesson. Where she really fucked up is the book. But for the book, I think she would have walked away clean. Maybe something would have come out, maybe months, years to come. But when that book came out, I only made $100,000 on this book. Pennies. Absolutely pennies. Nothing. This woman is so full of herself. It's staggering. It's disgusting. It's sad. It's scary. I wonder how much influence she's had on other cases too. Like, makes me wonder. There were so many questions that Poot had the opportunity to open the door for, and maybe it still wouldn't have changed the judge's opinion because clearly she was listening to the jurors' answers more than Becky's. But Becky is cooked. Thank goodness. Becky is going to be cooked one way or another. And no, Vanessa, he's not getting a new trial. The judge ruled no new trial. So, all right, everybody. Excuse me. I hope you all had fun. I hope you all learned something. I had a lot of fun doing this, despite the fact that I'm probably going to wake up with no voice tomorrow. But hey, hashtag worth it. So almost 7 hours of this, you guys. It's been a while. Happy to be back. We're going to continue doing streams, hopefully on the reg once again. And yeah, I'm excited to see what the future holds, not just on this case, but in other cases. You know, I'm going to be following the Rust story with Alec Baldwin. I'm going to be following the Sarah Boone case. Those two you guys mentioned, you definitely want me to be a part of, so I'm going to try my best. So we got Sarah Boone, we got Alec Baldwin from Rust, and we'll see what else we got. I definitely want to continue the UK saga once my voice comes back, since I'm going to need it for a 2.5-hour reading. And maybe we'll do, I know a lot of you have been suggesting I should do some more Curious George like kids book reading. I need more kids books, and like real ones, not, you know, what's her name? Somebody sent me like a couple of books. Brenda's Beaver Needs a Barber. That's not a children's book. Okay. That's not a children's book. Brenda's Beaver Needs a Barber is not a kid's book. That is an adult book. There was another one. If you give a kid a cookie, will he shut the fuck up? I think somebody sent that to me. I don't know if I'm going to read that either, as fun as it looks. That's also not a kid's book. I'm pretty certain with the F-bomb on the freaking cover of the book is not a children's book. So yeah. The Delphi murders. So what's his name? Koberger. I'm going to be following Koberger. as well, and I'll see how much my attention span can cover. I'll see how much my attention span can cover. Sorry, Zinnia is not in here. I'm not going to bug her. I've kept you guys here long enough. Thank you all for joining. Thank you all for coming to Raw Law Unfiltered with your host, the DUI Guy Plus. When I saw that this was happening, I absolutely knew, like, I absolutely have to do this. I have to do this hearing. So I'm very happy we did it. And thank you all for joining. I love every single one of you. And I hope to see you in the next video, whenever that's going to be, tomorrow, Wednesday, Thursday, but definitely very, very soon. If not, nothing else, I will be premiering the second part of the jury trial that I premiered yesterday. If you have not checked it out, go check it out. It's in my playlists and it's on my videos. It was released yesterday. It's the jury selection, and tomorrow I'll release the opening statements. And then I'll keep going piece by piece, and hopefully by either Friday or Saturday or Sunday, you're going to have the full thing. So I'm doing it piecemeal again. I'm trying to experiment a little bit, because I don't have that many trials to upload. So sometimes I let you guys binge watch and I just upload all of them, but not this time. So thank you all for joining. Sayonara, adios, au revoir, do svidanya, goodbye.